Good afternoon. This is the sentencing of the Parkland school shooter. I'm Janine Stanwood with our legal analyst, Craig Tricino. As you know, the state rested its rebuttal case last week. We believe that attorneys are now going to be discussing instructions for the jury. So let's listen.
Not click and read. They left it in black but didn't indicate that they had changed the language. So I think the first thing you need, if you don't mind me saying, is a colored copy of what the defense has prepared.
I don't have
I have that.
Oh, you have it.
Yes. Do you guys have one, I assume? Yes.
Do you have an extra one that you give me? Thanks. I think I've told you all this. We don't have a luxury of
Right, that's why I brought it.
colored copiers, right? Okay.
Judge, I also have printed out a copy from the website of the standard. Do you want this or do you want it just as a book? I don't know if you have a book up there. The actual standard instruction.
I'd rather not. I'll use the computer because
Okay.
the book they changed.
Okay. Well, I mean, I printed from the website. I don't know if you want this. We have an extra copy of this also.
But that's not all of them.
No, this is just 7.11. The standard instruction from the Supreme Court website, 7.11.
So right now it sounds like there's a little bit of paperwork that we're doing, but today we think there are a couple of things that are going to happen before the jury comes in tomorrow.
Right. Well, one of the main things that needs to happen is the what lawyers call the charge conference. So it's a discussion about the jury instructions and what instructions are going to be read. If one side has an objection to one of the instructions, and then they'll hash it out with the judge, and the judge will finally make a ruling on what exact instructions the jury is going to be here after they hear closing arguments. There's also apparently a couple of motions outstanding. Looks like one from the state and two from the defense. I'm not exactly sure what the contents of those are at the moment, but it looks like that's what the judge might be currently reviewing on the bench right now, because they were all filed, it appears, yesterday.
A couple filed yesterday. This was filed today. Talk about what this means. A motion in limine means.
Yeah, motion in limine is Wait, the judge about to speak?
Instructions, and I have the standard instructions in front of me. But I think the easiest way to do it is to take the standard instruction and go paragraph by paragraph and ask both sides to tell me if they have any proposed changes. Does that?
Works for the defense.
That's fine, Judge. I just have one thing I'd like to put on the record before the court begins that process, if I may.
Okay.
Judge, I'd like to turn the court's attention. There is case law, Stevens versus State, STEPHENS versus State, 787, Southern 2nd, 747 at 756, where the Florida Supreme Court stated that while a defendant is entitled to have the jury instructed on his theory of defense, the failure to give special jury instructions does not constitute error where the instructions given adequately address the applicable legal standards. The trial court in the instant case gave the standard jury instructions for first-degree felony murder. The standard jury instructions are presumed correct and are preferred over special instructions. That is from Stevens versus State, and more recently from the Second District Court of Appeal in 2020, Grant, G-R-A-N-T versus State, 311, Southern 3rd, 156, at 162. The standard jury instructions are presumed correct and are preferred over special instructions. Admittedly, the trial court does retain some discretion as to the use of standard instructions, particularly when there is a problem with a standard jury instruction or when a standard instruction is inappropriate in a particular case. However, if the trial court determines that a particular standard instruction is erroneous or legally inadequate, the court may modify or amend the standard instruction, but it also must state on the record or in a separate order the respect in which the judge finds the standard instruction erroneous or inadequate and the legal basis for varying from that instruction. This procedure is important because both the confidence in the use of the standard instructions is undermined when their use is rejected without explanation.
Okay, and my preference, as you all know, because we've dealt with some instruction issues, is to follow the standard instruction. I'm happy to consider arguments as to why I shouldn't follow it, but my opinion is that the standard instructions were drafted for a reason, and unless somebody can explain or convince me why the standard instruction should not be used, my preference is to err or to err on the side of the standard instructions. And I'm not sure if err is the right word, but you all know what I'm saying. Okay, so 7.11, final instructions and penalty proceedings. The first paragraph, is there any objection to the first paragraph? It appears both sides are in agreement that the first paragraph should be included. State?
Judge, I did include the paragraph as is, except when the sentence in the center of that paragraph, they say, imposed upon the defendant for the crime of first-degree murder. Because our case is very different from most cases, and we have 17 counts of first-degree murder and 17 counts of attempted first-degree murder, I did change the wording to reflect that by saying the appropriate sentence that should be imposed upon Nikolas Jacob Cruz for the 17 counts of first-degree murder charge in the indictment. So the only change I made to that was to clarify that there has to be a decision to all of the 17 counts. And I think that would be an important aspect throughout the instructions and in the verdict forms, that there has to be separate verdicts.
And both sides have been in agreement that I should distinguish that there's 17 counts in this case. When I read the initial comments to the jury, I do think it should say each as to the appropriate sentence that should be imposed upon the defendant. Hold on, I'm sorry. For each of the 17 counts, they should distinguish the fact that to remind them that they have to impose a sentence of life or death on each of the 17 counts and not as a whole. Is there any objection to adding for each of the 17 counts?
No objection from the state judge.
Judge, we don't have an objection to that. However, the addition of charge in the indictment, especially if Your Honor is going to change it to say for each of the 17 counts of first-degree murder, they're not. That language, charge in the indictment, is not part of the
Where are you?
I'm sorry. So after 17 counts of first-degree murder, the state has added charge in the indictment, and I believe Mr. Klinger was saying to try to clarify that each of the 17 counts would have to be considered separately, that's why he put that language in there. And if Your Honor is going to clarify by saying for each of the 17 counts of first-degree murder, I don't think it's necessary for charge in the indictment, and it's also not language in the standard instruction.
Your Honor, the jurors will be able to see the indictment, and I think it just makes it very clear, again, that there are 17 counts of first-degree murder in the indictment.
By the way, State, are you going to be so kind as to when I indicate changes that need to be made, are you all going to do that, or
Yes, ma'am.
do you want my
I'm not
office
keeping track of it, and we can
to
go
do
ahead
it?
with
I know normally the state does that for the court, but technically it's my job. So if you want someone from my staff to do it, that's fine. I just have to let them know.
Judge, we have all of this in Word and on
Okay.
computer. It would be very simple.
Okay, I appreciate it. All right, as charged in the indictment is going to remain in. I think that is for the jury's understanding and nothing more. All right, how about the second? I see the state has added the second paragraph. Each crime and the evidence applicable to it must be considered separately, and so on and so forth. Indicated at the bottom that the paragraph was added from the language 3.12, single defendant, multiple counts. I think that is a necessary addition.
Judge, we would be objecting only because we do not feel it is necessary. They've submitted 17 separate verdict forms. You will read off 17 separate verdict forms. You've now clarified and said each of the 17 counts. And on page 14 of at least the state's proposed instructions, it discusses again that there are 17 separate verdict forms.
Judge, Ms. Patchen is correct. I believe it's on the top of 15 in the state instructions. But again, this is a very important point for the jurors to realize and to hear that there has to be these individual decisions made as to each count. And this paragraph also says that the crime and the evidence applicable to each count is what you need to look at for the appropriate sentence. So
Ms. Basham, why are you opposed to making it more clear to them?
Because it's said multiple times throughout. It makes no sense to continuously remind them of that. They're able to read and you instruct them properly, along with reading 17 different verdict forms. So I'm not sure why it's necessary.
Your Honor, if I may.
Over the defense objection, I'm including that. It's included for a reason. I think that normally in a first-degree murder case, there probably isn't 17 counts, so that option hasn't been added.
And for the record, Your Honor, this point is going to come up again and again, and I would cite to the record under Pangburn versus State, and it came out of this circuit. Each victim is supposed to have its own verdict form, and it's error not to. Plus, under the Eighth Amendment, the defendant is entitled to individualized sentencing, and he has pled guilty to 17 counts of first-degree murder. So for those reasons, this issue is going to come up and up again. We have streamlined these jury instructions as to not make it repetitive, but this is an issue that the defense is going to keep objecting to, and the reason the state has put it in here is because of Pangburn and because of the Eighth Amendment. It is necessary.
Okay, so with that said, State, you're gonna take off the underlined part and take off the footnote?
Yes, ma'am.
Please.
Yes.
Okay, the third paragraph that begins, in making your decision, you must first unanimously determine. Is there any objection? That appears to be the standard language. Is there any objection from the state?
No, Your Honor, I believe I copied that.
Okay, is there any objection from the defense?
No, Your Honor.
Okay, so the standard language says the next paragraph should begin, the aggravating factors alleged by the state are, and then to list them. The defense has suggested that we say how many, first of all, Roman numerals are really not my preference, mainly because I am not good at them, especially when you get up to whatever XV11 are. My preference is to write the number. I know that's how you all do it in the indictment. I know that's how it's done. However, if we can, I'm going to assume that if I don't remember being taught Roman numerals in school, that maybe at least one of the jurors hasn't, and I would like to stick to numbers, actual numbers.
That's fine.
We don't want them fixating on that, because I would be going, what, it would give me X? I mean, I'm sure collectively they could figure it out, but why, right?
Sure.
Maybe I'm the only one that wasn't taught Roman numerals in school, I don't know. All right. So you're suggesting just that we say how many aggravating factors are alleged, the number?
Just so the way that, and the notice of intent to seek death does not reflect this. However, in subsequent pleadings, the state has indicated that all but 2 of the alleged aggravating factors apply to every count, and then 2 of the aggravating factors, the disruption of a governmental function and the elected or appointed official aggravator, those only apply to the 3 staff members. So the way we did it, just to make it more streamlined, is to say the aggravating factors alleged by the state for counts 1 through 17 are, and then list the 5 aggravators the state intended to apply to every victim. And then if you skip down a little bit, it says, and I forgot to put this one in green, that's my error, but on page 4 at the top, it says additional aggravating factors alleged by the state for counts 9, 11, and 12 are, and then the 2 that are only meant to apply to the staff members. Then I think that makes it pretty clear that they are alleging that the aggravating factors apply to every victim except those 2 which only apply to the staff.
I gotta tell you, both ways are confusing to me when I'm reading these. Let me just look at this again, please. So there are 2 alleged aggravating factors that only apply to 2 victims.
3.
3 victims, the teachers, the adults.
Yes.
That's 9, 11, and 12. The difference between what the state did and what the defense is asking to do is that we put at the end of each aggravator. So if you look at aggravator 1 and you go to page
Oh, I see.
4 at the top, you see this aggravator applies to all 17 counts of first-degree murder. And I'll tell the court in advance that the first aggravator has to do with the prior violent felony and contemporaneous convictions. And it's a more difficult aggravator to lay out than the rest of them. So we're starting with probably the one that's the most difficult to go ahead and get the wording correctly on.
I'm sorry. Will you repeat that, please?
Sure.
I was looking at the...
No problem, Judge. So the first aggravator in this case is the prior violent felony. And that can be proven through contemporaneous convictions, or it can be proven, as we did in this case, convictions for Sergeant Beltran and the other case defendant,
pled guilty to. This factor, more than the other factors, needs extra language because it's not defined very, very well in the jury instructions when it comes to contemporaneous convictions, because a lot of the times there's only one victim and there's not a whole, like we have here, we have 17. So, but before I get to that, the defense wishes to put at the beginning the aggravating factors alleged by the state for counts 1 through 17 and we have chosen to follow the jury instruction, leave it as the aggravating factors alleged by the state are, and at the end of the aggravator, and that's on the top of page 4 for the first one, we wrote, this aggravator applies to all 17 counts of first-degree murder. That way the jurors would hear the aggravator, and then they would hear that applies to all 17 counts.
Let me ask you all a question. Is there any reason why we can't put aggravating factors, number 1, and give whatever the abbreviated name for that aggravator is, put that in bold, then give the instruction and say this aggravator applies to the following? Like, in other words, when I look at all these paragraphs, I'm thinking this is sort of like a bullet point, like make a bullet point for them to know aggravator number 1. What is the abbreviated name for aggravator 1?
I think that maybe the way to do it, Your Honor, is if you wanted to bold the very first sentence, because that tracks the language, where it says Nikolas Cruz was previously convicted of other capital felonies or felonies involving abuse or threat of violence to the person.
Yes.
Because if you bold that, then everything that the state has drafted underneath it, under subsection A, tracks the other capital felonies, because they're contemporaneous convictions, because where there's one episode with multiple victims, those contemporaneous convictions count as prior felony capital convictions for purpose of this aggravator. And then the following paragraph, which it says the attempted, which were the non-homicide counts, also count as contemporaneous convictions. And then paragraph C, which relates to Deputy Beltran, is the second part of the first sentence that will be bolded. So that the jury will understand, as you're pointing out, that the aggravators are defined in the first bold sentence, and then everything else comes underneath it.
Is there any objection to doing it that way?
Yes, Your Honor.
Because?
So the objection is we would be fine with just saying this aggravator. So, for example, paragraph.
First, I'm just talking about bolding the first line so that they know it's sort of like a bullet point. Like the first aggravating factor is being previously convicted of other capital felonies or felonies involving the use or threat of violence to another person. So that they say, okay, that's the aggravator, and here's the definition of it. And then the next one, 2, with the actual aggravator being bolded, okay, here's the aggravator, and here's what it is.
Judge, we don't have an objection to that.
Just the bold part. Okay, so what is your objection?
Right. I mean, the objection is that the way that the state has it set up now is too wordy and confusing. Now, if you were to bold that first part, for example, paragraph 1, right? And then the crime of murder in the first degree is a capital felony, and then say underneath it, say this aggravator applies to all 17 counts instead of listing all of the counts, it would be clearer for the jurors. I mean, they've done that on other aggravators. I'm not sure why it was necessary to do it like this.
The reason that it's necessary is that if you have one victim, the other 16 apply to the one. So that's why you list it out.
I understand. So
There isn't a shortcut when there are 17 victims of a homicidal episode, Your Honor.
And I think the jury understands that there's 17 counts if you say this applies to all 17 counts.
And then you have 17 attempted first-degree murders. There really is no shortcut. You have 34 contemporaneous convictions, and then you have 3 priors regarding Beltran. I mean, we have 37. We have 37 prior convictions under aggravator 1 here. So we have to spell it out. We don't want a problem in the Florida Supreme Court. We don't want jury questions coming back about how does this work, because historically this is where the jury could get confused unless they are explicitly instructed.
And Judge, I just respectfully disagree. I think this is very confusing how it's written.
Your Honor, in one of my cases with Judge Holmes, this actually became an issue. There was a juror question about contemporaneous convictions. So it has to be set out properly. In most cases, when there's contemporaneous convictions and you have maybe 1 or 2 or 3 victims, you would go by count. Each victim's count, you would have the aggravators listed underneath that count. So if you had 3 victims, count 1, it would read who the victim was, and then the contemporaneous would be the names of the second, the B person.
I don't disagree with you. I'm just trying to
So that's why we didn't
see
do
if there's
it
a more clear way to explain this, because it's a lot.
Judge, did you want, after we bold that first sentence, to move the instruction the court further instructs down, separate it out?
Yes, I think that should be the next paragraph. Please.
Yes.
Judge, underneath letter A on page 2, the crime of first-degree murder is a capital felony, right?
Okay.
And then when you go down and you read, I mean, I think they're going to get lost in reading, and I understand why the state wants to put all the victims' names in there, but it says the exact same thing. It just says that lists them all. I mean, this doesn't say anything more than the crime of first-degree murder is a capital felony. It just lists out those crimes. I mean, or the victims' names. It says the exact same thing. It just says it in like 2 pages. Subsection B, the crime of attempted first-degree murder is a felony involving the use or threat of violence to another person. And then you go down, that paragraph says nothing more than that, except it just lists names. I mean, it's just repeating the same thing.
Your Honor, there's an alternative to what the defense is objecting to, and that is where you have multiple victims. And this is going to be redundant, and it's going to take a long time. But in the Hojan case, and from Judge Backman, there were 2 homicide victims, and I can approach the court and show you how I did jury instructions for that case, where each victim had the aggravators applicable to the victim listed underneath the victim. Now, that would take a very long time to read, because for each victim in our case would have 16 other victims listed for first-degree murder, another 17 for the attempted first-degree murder, and then the other 3 regarding Deputy Beltran.
So I'm not concerned about the length of time. I just, you all have done this multiple times. I don't think it's a surprise to anyone to know that this is my first death penalty case, and I am looking at these instructions thinking this is not extremely clear, and I have a law degree and I'm a judge. So I'm just wondering if there's no other way to make it more clear or more simple, then that's okay. This is how we'll have to do it. And I certainly don't think that, they need to understand that the consideration for the first aggravator is for each and every act that Mr. Cruz did, and each and every murder and each and every attempted murder. And certainly I don't want to downplay that there was 17 plus 17, but I'm just wondering if there is a way that it can be just a little bit more.
Well, Judge, in the first paragraph, after the portion that we all suggested, or that you suggested be highlighted, then there's this underlined part in the state submission where it specifically says, the court further instructs you that where a defendant is convicted of multiple murders arising from the same criminal episode and involves multiple victims, the contemporaneous conviction of murder in the first degree or attempted murder in the first degree as to one victim may support the finding of the prior violent felony aggravator as to the murder of another victim. And then they list the crime of first degree murder is a capital felony, and then on the next page, the crime of attempted first degree murder.
That may be clear to you as a lawyer, but that's not going to be clear to the jurors, I don't think. Leaving it just at that. All right, why don't we skip over this issue for now? I think that if you can, how long would it take you to type it up the other way?
You mean for each count?
It's going to take a long time.
Yes.
Can you do maybe one so we can see how it looks? No? Or do you want to show us the Judge Backman
I can, Andrew,
instruction to both sides so that I can just...
Now, there were 6 aggravators, if I may approach.
Sure. I just want to see if visually this is... Thank you. Do you want to come look at this? Somebody? Have you all seen this?
I was going to send them a copy. I can send both the court and them a copy of via email.
If I understand this is going to take a long time to do. However, if you assume that they're going to go through everything one count at a time, one victim at a time, I'm trying to put myself in the juror's shoes. If I have an instruction for each count, to me, that's a lot easier to follow. Do you all want to take a look at this? So basically it has aggravating factors for count 2, then it has the victim. So it would be for count 1, and then for count 2, and then it would list them. I think that is, and then bold the actual heading. To me, that is a lot easier to follow. And then they could actually go through the counts with the instruction.
So is it the full instruction?
What
For each one?
Why don't you
emailed it to you.
why don't you take a look at it?
Either. Sorry. Whatever your preference, John.
And that's going to be like hours of work, right?
Well, if we have someone start on it now, it can be done. It's gonna take a long time to instruct a jury, depending upon, I think you wanted, what time did you want them back tomorrow morning? Was it 8:30?
Mm-hmm.
It'll take several hours to read it, but it's, it can be done.
Again, so for each count, you would be reading the 16 names for attempted, for first degree murder, and the 17 names for attempted first degree murder. For each of the 17 counts. That was the reason why we changed course in this case, in this particular, this set of instructions. But that can be easily, we can change it.
I mean, if I was a juror, I think that way is a lot easier to follow. But again,
What we can do is we can print up one, so you know, it applies to this case exactly. You can see how it, that way you can see how it looks.
you see how each count is, the aggravators for each count are listed.
So, Craig, we're listening to them really sort of the nitty-gritty hashing out how they're going to present these instructions to the jury, and it is confusing. There are 17 victims. There are separate aggravators for each. I think the majority of them is one, but then there's some that apply to the teachers.
Right, not all the aggravators apply to each one of the 17 victims, but each one of the 17 counts needs to be addressed independently by the jury.
Okay, let's
Types of
listen.
ammunition in your house and you're a convicted felon. It's not 5 counts of possession of ammunition by a convicted felon. This aggravator, they find one prior violent felony, it's one aggravator. Okay, they don't get it 17 or 16 times, 17 times. So the way that they're describing to do it not only will take the entire day, but it's also, you're going to lose these jurors after a while, and it's misleading in the sense that it makes it seem like it's 17 aggravators, and it isn't. So, I mean, I'm not thrilled with the way that they did it in the original, but it's certainly better than the alternative that has just been proposed, and I think maybe there's just a way, I mean, maybe we can take that second sentence that's underlined and make it a little bit less confusing to read for the jury, and then just instruct them a contemporaneous felony or contemporaneous conviction for murder or attempted murder may support the finding, and then just tell them that it's, I mean, we're saying this now 4 times, which is fine, but I think it's too misleading the other way, and it also makes it seem as if this is an aggravator that applies 17 times.
It does. It applies to all 17 counts.
Right, but it's one aggravator. It's not 17 aggravators.
Well, actually, it's 36 different violent felonies.
Because they could find that the murder of Luke Hoyer, Gina Montalto, and Alexander Schachter do qualify as an aggravator, but for whatever reason, the 3 other victims don't. Could they not?
But then it wouldn't matter, because then it would be proven. It's one aggravator. If they don't find it for everybody, it doesn't make a difference. Or if they decide they didn't think the Sergeant Beltran case was a prior violent felony, if they find even one other murder or attempted murder, the aggravator's proven. It's not that they can find this and have it apply 17 or 30 whatever times.
Judge.
It's one aggravator, just like possession of ammunition by a convicted felon. It's one count. Doesn't matter if you have 1 bullet or 1,000 bullets. It's one count.
Judge, it does matter because this is about weight, not counting. So you could have one, it is one, Ms. Curtis is correct, it is one aggravator, but is it the size of a pebble or is it the size of the sun?
Okay.
And the more convictions, it makes it a more weightier.
All right, but I'm going to keep it the way the state originally proposed. However, is there any objection to me only reading the name and not the count unless you want to put the number, the actual number? Can you put the number in a parentheses? In other words, XB11, paren 18?
We've already changed. We've changed it to the actual, just the number 1,
Oh,
number 2.
perfect. Because I know you're mirroring what's in the indictment.
Right.
So I don't know if you wanted to keep that, but for purposes of making it a little bit easier on me and maybe some other jurors, putting in parentheses just 1-8 or 1-9. See what I'm saying?
I see what you're saying. So for the Roman numeral II, it would be in parentheses 2.
Correct. Please,
Sure.
if you don't mind.
No problem.
Judge, I do have objections to the Beltran charges.
Okay, hold on just a second, please.
I just want to make sure you understand.
Also, okay. What I would like to do is, do you see on page 2, you have a paragraph that describes aggravating factors, then you have aggravating factors. I would like all of the pages that deal with aggravating factors to say, like at the top, aggravating factors, page 1 of 10. Do you see what I'm saying? Aggravating factor, page 2 of 10, 3 of 10. That way, the reason I like to do that is, let's just say in another case where there's an instruction that goes on for multiple pages, if these pages get, and I know you have page numbers on the bottom, but still, if they want to separate out specific instructions, they can do so in the back.
Okay.
Does that make sense?
Move it to the top, or leave it where it is, but also put on the top.
I think leave it where it is and then also put it on the top. Aggravating factors definition or aggravating factors page 1 of, on the top.
Is there still going to be a page on the bottom?
For now, let's leave the page on the bottom. Or maybe I just don't normally have pages on the bottom. It's been a while. Nicole? We don't have pages on the bottom? I just want to leave the page numbers on the bottom. I want it to be clear for them that every one of these pages deals with a definition of an aggravating factor. When we get to the mitigating factors, same thing. That they know they don't have to be really trying to study these to figure out what goes with what, even though there are page numbers. Okay, Ms. Basham, you were saying?
Yes, Judge. So for paragraph 1C, D, and E.
What page are you on? Let's definitely leave the pages for today's purposes, making it easier.
The bottom of 3 into 4.
Okay?
3 charges stemming from the Beltran case. And I just wanted to renew our previous arguments that we made in DP 50, which is the motion to preclude use of conviction in case number 18-14129 CF10A as an aggravating factor under 921.141 subsection 6 subsection B. And we would also like to say that even if it should, these charges be submitted to the jury for consideration as an aggravating factor, that we would like an instruction to the jury that would allow the jury to decide if these crimes are ones that constitute threat or violence to a person.
Okay, your argument is preserved, but your request is denied. We've had argument on this issue previously. Okay, so we're going to bold the number 1s. I also think that the A, B, and C and D and E should be bolded.
Judge, I'm sorry, if we could go back to E on number 1. I don't know that, I may be remembering incorrectly, but maybe we could pull the actual exhibit, because I thought it was only the 2 convictions that were used and that the rest was like taken out.
Well, what the misdemeanor wasn't included, but that was.
I didn't think that depriving the officer of a means of protection was.
I don't remember.
It's my recollection it was, but we could look at the
Sure.
Yeah, I don't remember.
evidence, I believe it was, but
Okay.
What was does anyone have the case number offhand?
18-14129.
014129?
Judge, I'm talking about the
Right.
in evidence, what we did, what the court ruled is what.
I ruled the felonies qualified, the misdemeanor did not. I was just going to look up the case number to see which one was the misdemeanor.
Right, I
charge.
just thought maybe we might not have included this count, even though it is a felony count. I don't know that we included that in the, if we could just maybe pull the exhibit and take a look at it. But it doesn't have to be right now. We could, if we are correct, we can just omit that, but if not.
Do you know the exhibit? We'll get the exhibit number.
It's
Conviction of
Sergeant
Beltran. Sergeant Beltran conviction.
I have the exhibit. What number? I have the exhibit number. What's it? 480 would be the judgment and conviction, and 481 is the disposition.
It was attempted use of. Oh, I don't remember. All right.
And Judge,
Hold on just a second,
Okay.
please. Okay, what were you saying?
I just wanted, so that we don't have to do this with each one, we, in the pleading that we filed, the footnotes for each of the aggravators renew the objections that we've made previously as to the constitutionality and all of that, of each of the aggravators.
Okay.
We can move on and deal with that issue about whether this was included in the exhibit or not
I just don't
later.
want to forget. Are you looking it up? Can you? Please. All right, if you move on to page 4, the aggravator, so you're going to bold all of the aggravators.
So on page 4, with Nikolas Cruz knowingly created a great risk of death to many persons would be involved.
Please. And then number 3, the first degree murder was committed while Nikolas Cruz was engaged in the commission of a burglary. And then I read the definition of burglary. Is there a reason why that's in underlined?
I added in the definition, Judge. It wasn't in the standard.
Is there any objection to adding the definition of burglary?
No, Judge. However, we want to make sure that obviously the underlining comes out, and then I think first degree murder might be italicized. I'm looking at 2 different copies, so.
Burglary is defined as the entering of a structure without the permission or consent, owned by or in the possession of the Broward County School Board, and at the time of the entering the structure, Nikolas Cruz had the intent to commit the crimes of first degree murder. Okay, so we're going to take out the underline and the italicized.
Right, and we would ask that for, unless the standard instruction has something italicized, we would ask that, because that's just to highlight something. So we would ask that any underlining and italicized words,
And
or
the
italics be removed.
And the footnote on the bottom needs to come out too. Then paragraph 4, the first degree murder was especially heinous, atrocious, or cruel. That part should be bolded. Then I'll read the definition of heinous, atrocious, or cruel. Paragraph 5, the first degree murder was committed in a cold.
I'm sorry. We have an objection
Okay.
to where under the first degree murder was especially heinous, atrocious, or cruel. If you go down to the paragraph that starts the kind of crime,
Okay.
intended to be included as especially heinous. In the state's proposed, they don't have the word especially, which is the proper verbiage.
Okay, hold
for
on a
that
second.
Aggravator.
the standard instructions state, I think you just left out a word. I don't know if you did it on purpose, but the kind of crime intended to be included, it should say the kind of crime intended to be included as especially heinous, atrocious, or cruel.
I left out included as.
Kind of crime
Included as a special.
intended to be, I think you left out after B, intended to be included as especially, those 3 words.
Yes, I'm sorry about that one.
That's okay, so you're going to add those?
Yes.
Okay.
Judge, I also have another
Go ahead.
question. First I'll start with at the end of that paragraph, it says unnecessary torturous to decedent.
Hold on one second. It says,
I'm talking about the standard instruction.
all right, I'm looking, hold on. Okay, I'm where you are.
Okay, so we would request that be changed to decedent and for the counts to not be listed out. We already have them listed out now on paragraph 1. And underneath that paragraph where all the counts are listed, it says this aggravator applies to all 17 counts of first-degree murder, which I think is very clear. I understand what the state's argument was as to the prior violent felony, but it's very clear if you say to the decedents, this aggravator applies to all 17 counts of first-degree murder, and it's unnecessary to list the victims' names again.
Judge, it's in parentheses, and that means it needs to be filled in. Normally, again, when we go back to just having one count.
I understand. I agree that the decedents, you don't say decedent, you say the person's name. However, take out the count 1, count 2, and I'll just read their name. Please.
Okay. No problem.
And then rather than saying the aggravator applies to all 17 counts,
Judge, if you're going to read each of the names, then maybe we could just take out the aggravator applies to all 17 counts.
Judge, for clarity's sake, at the end of each one of these, we were saying what the aggravator applies to, especially when you get to 5, 6, and 7, it only applies to 3 of them. So.
I understand. All right, leave that part in because we've been doing that for each count, but just each aggravator, but take out the number, please. Okay, paragraph 5 on page 5. The first-degree murder was committed in a cold, calculated, and premeditated manner, and so on and so forth. That should be in bold. Then I will define cold, calculated, premeditated.
Judge, this is the standard instruction. We don't have any objection to it. Number 5.
Okay, number 6. The first-degree murder was committed to disrupt or hinder the lawful exercise of a governmental function or the enforcement of laws. And then if you would please put after each Roman numeral in parentheses the actual number.
Go through that.
Judge, we would just make the same. I mean, given the court's rulings on the previous aggravators that we didn't want it done this way, we have the same objection, but given that that's how we're doing it, we don't have any additional objection to the way that this is worded.
Okay. And then number 7, bold, please, and then,
Judge, we do have an objection to number 7.
I'm sorry?
We do have an objection to paragraph 7.
Okay, what is it?
So as written in the standard instructions, it is decedent, was an elected or appointed public official engaged in the performance of his or her.
Let me get to the standard, please.
And it would be paragraph 11, Judge, in the standard instruction.
Okay, I'm on the standard, I'm on the state's. So it's the state's paragraph 6, the standard paragraph 11, and what is your objection?
Okay, so our objection is that this is not the full standard instruction. That's the first objection. They are leaving out elected or, and it's misleading because the full language is illustrative of what the aggravator is for, which is the intentional murder of a political figure. Also, where they say the victim was an appointed, so we would request.
I'm sorry, I've lost you.
Okay.
I'm trying to read yours, theirs, and the standard. And
So
we're on paragraph 6 of the state's proposed, or 7?
7.
Okay, will you just summarize your objection again, please?
Yes, it's not the standard instruction. They've left out and elected, which is the instruction.
The instruction should read, the victim was an elected or appointed official engaged in the performance of his official duties if the motive for the first-degree murder was related in whole or in part to the victim's official capacity.
Was he elected or appointed?
Well, and that's a point of contention, Judge. We're also objecting to the language after, and we're asking that it simply say, this aggravator applies to the first-degree murders of count 9, Christopher Hickson, count 11, Aaron Feist, and count 12. It's for the jury to determine whether they're appointed officials. We do not agree with that they are appointed officials. They're hired staff at a school.
Okay, but is there any evidence that he was elected?
No.
So why do we need to put that in there?
Because that clarifies the purpose. The reason that we're saying that this aggravator doesn't apply to them is because this aggravator was designed to aggravate murders of political figures or, because of, like Robert Kennedy, for example. It's not for a school shooting where a teacher is murdered. That's our position. They are not appointed or elected, and the murder was not for the purpose of, so we're asking that the jury not be instructed that they are appointed public officials engaged in the performance, that we just use the exact language from the standard instruction, and then just say, this aggravator applies to the first-degree murders of, and let the jury decide.
Well, the jury's going to have to decide whether it is or not, but you don't keep language in an instruction where there's no allegation that particular language is true. The state still has to prove this beyond a reasonable doubt, but why would you keep elected if there's no allegation that he was elected? That's like...
Because, Judge, it puts the aggravator in context. There's no definition or further instruction on this. It's going to be for the jury to decide. And if they read the actual instruction, which was an elected or appointed public official, then they may determine, oh, this doesn't seem to be the kind of thing this is meant to apply to. When you leave out the elected part, it's misleading in the sense that it doesn't really capture the essence of this aggravator.
Your Honor, if I may be heard on this?
Sure.
Your Honor, in the course of, where it lists all the sexual battery, aggravated child abuse, arson, burglary, you don't read all of them and then let them choose. You read burglary for our case. You don't confuse the jury. And there's also case law to support the premise that you don't, shotgun it where you read everything to the jury and then argue that, oh, well, this doesn't apply and that doesn't apply and this doesn't apply. I can find the case if you want me to read it into the record, but that's what the law is. And that is what the defense is asking you to do. They have been asking not to mislead the jury, and yet they want to leave in the word elected official for this jury instruction, when clearly we know that these adults who were murdered by the defendant were not elected. we've already had the argument where you ruled that this aggravator applied to these victims.
All right, is there any other objection to number 7?
Judge, I just wanted to add one thing. Ms. McCann had stated that you don't put language into an instruction that doesn't apply, and she listed, those forcible felonies that in the standard instructions are considered in parentheses showing this is what you would pick, one of these, 2 of these, but it's not the actual language as is paragraph 11 of the standard instruction.
But you all are in agreement that there's no evidence that he was elected. And there's no allegation that he was elected.
Right, we agree with that,
But you want
but
me
we
to
also
instruct
find
them?
no evidence that he was appointed. So that's the problem.
Could you repeat yourself?
I'm sorry. There's no evidence that they were elected or appointed. That's the problem. And the problem is by not reading the actual instruction the way it's written, it gives it a meaning that's not its intended meaning. And so we're objecting to leaving out the word elected because that word, even though there's no evidence that it was that the people that these victims were elected officials, it puts in context what the purpose of this aggravating factor is for, and we believe that the state has not proven this aggravating factor, that they are elected or appointed, and so to leave out that word misleads the jury.
All right, I'm going to overrule the defense objection. I'm going to order that 7 stay the way it is.
Judge, so are you also saying that the language underneath for count 9, Christopher Hickson was an appointed public official engaged in the performance of his official duties? Because we're not agreeing to that. That is for the jury to decide whether they're...
These are aggravators that have to be proven beyond a reasonable doubt. I'm going to assume that you're not agreeing to any of them. Isn't your argument that they're going to be that the state didn't prove their case?
No, but...
It's not?
Well, I don't know what our argument is going to be at this point, but my point is the way that this is written, you are instructing them that Christopher Hickson was an appointed public official. That's different than defining what cold, calculated, or premeditated means. This is you telling this jury that Christopher Hickson was an appointed public official.
Okay, I've heard your argument. We're going to have to agree to disagree, all right? Thank you. Over the defense objection, 7 is going to say the same, the way that it is proposed by the state.
And Judge, we will bold the first.
Please.
And also, would you want the actual number after the Roman numeral?
Please, if you can put it in parentheses.
Yes, ma'am.
Now, the next paragraph on page 7 in the middle of the page, that starts... Okay, so that's still part of aggravating factors, telling them what they can't consider as an aggravating factor. Is there any objection to the middle paragraph? State?
Judges, that's the paragraph regarding victim impact?
Yes.
Yes, we have an objection.
Okay, what is it?
Anywhere that it states evidence, we would object to that word and would request to use testimony. And we would renew our arguments that we made in DP 39, which is the motion to include use of the term evidence when referring to victim impact statements or information. It's misleading to the jury as it cannot be considered as an aggravating factor.
Okay, I think it's the state. Is it the standard language?
Yes,
Yes.
Mr. Ryan.
And then also, Judge, we would object to the listing of the victims' names, but again, based on the court's previous ruling, we would just make the same objections.
Now, state, I could be mistaken, but I don't believe that, was there impact testimony for each of them?
Yes, Your Honor, every victim in this case, each family gave a victim impact statement.
Okay, I just want to
And
make
the
sure.
instruction clearly leaves a place to insert the victim's name.
Okay, thank you. So, over the defense objection, I'm going to give the standard language in the second paragraph of page 7. How about the final paragraph that goes from page 7 to page 8? Is that the standard language state?
Yes, ma'am.
Is there any objection?
I'm sorry, give me one moment.
And actually, my question goes to the remainder of the aggravating factors instruction, because it looks to me like it's all of the standard language, starting with the paragraph as explained before the presentation of the evidence.
That's all the standard language. Up and through two mitigating circumstances.
I'm sorry, Mr. Klinger?
Until we get to mitigating circumstances, and that was all the standard language that was for aggravation.
Okay, so there's no objection to the remainder of aggravating circumstances.
Well, Judge, we put in our version, and it's on page 4, some language we would like. The paragraph starting with a finding that an aggravating factor exists, and that would be on the state's version, the second to the last paragraph on page 8. We would ask that the beyond a reasonable doubt be added. A finding that an aggravating factor exists beyond a reasonable doubt must be unanimous. That is the standard. And then at the, well, I don't know, are we also moving on to page 9?
I'm listening.
Okay. If we're going all the way up through the mitigating circumstances heading, we're asking that a sentence be added after the very last paragraph, because it doesn't explain that the jury has to unanimously find that the aggravating factors are sufficient to justify the imposition of the death penalty. So we're just asking that a sentence be added, and we have it included in our on page 5. We would ask that it say specifically, you must unanimously find that the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify a possible imposition of the death penalty.
Judge, that comes later in the instructions after mitigating circumstances. They're skipping ahead. At this point, it's just for the jury to determine that an aggravating factor exists. And then we're moving on to mitigation. So at that later in the instructions, we'll be talking about the sufficiency of the aggravators. It's not the place for that sentence to be.
All right, I'm going to give the standard instruction. I think it's sufficient, I think it's clear, and I'm going to give the standard instruction. All right, moving on to mitigating circumstances. State, if you can do the same thing for mitigating circumstances, please. In other words, start it on its own page, and at the top, put mitigating circumstances page, whatever it is, one of however many, and do that on the heading of each of the pages.
Yes, ma'am.
Judge, I'm sorry, before we start going through that, can I just run to the restroom real quick?
Sure.
Okay. Can I go back here?
I don't know if...
Oh, I can just go
Oh,
out here.
there's no jury, it's fine.
Well, there's nobody out here either. I can just go out here. I'll be right back. Thank you.
So, Craig, the jury has a pretty big task ahead of them, and they're going to be presented with what we think, at least according to this draft, 92 pages of jury instructions.
Yeah, well, there's a lot of instructions. Generally, in any case, there's a fair amount of instructions, but here we have to go over the instructions 17 different times. And each individual victim has to be instructed individually because the jury needs to make a decision 17 different times on each individual victim.
And once
so
again,
it becomes complicated and a little cumbersome, and everybody's trying to get it to the point where it's not confusing to the jury, because if it becomes confusing to the jury has a question, they have to write the question down, hand it to the bailiff. Bailiff brings out in the court. They got to get everybody back into court, and the question has to be read on the record in open court, and that's cumbersome. So the idea is to get all the information and the instructions to the jury so they can do their deliberations with the minimal amount of questions.
Well, even the judge said, and she admitted that this is her first death penalty case, but she even admitted, listen, I'm a judge, I have a law degree, and it's confusing to me.
Right.
So let's just remind our viewers who are watching that these jurors have to consider each of the 17 counts. So 17 counts, one for every person who
Correct.
died, and they have to do it separately. And what makes it confusing a little bit is that the attorneys are both sides are arguing, the state, of course, is arguing that the aggravating factors ought to outweigh some of the mitigating circumstances. The jury has to consider the weight of each, and that's how they come to their decision.
Right.
In a death penalty case in the state of Florida, if you are to recommend death, it has to be unanimous. For each count.
For each victim.
Each victim.
Right. That decision has to be unanimous. So they have to unanimously find that a particular aggravator, let's call them, because there's, I think, 7 for most of them. Let's call aggravator A, B, and C for sake of argument. The jury has to be unanimous on aggravator A being met, and then unanimous to decide that the mitigating factors did not outweigh aggravator A. If the 7 of the jury say aggravator A was met and 5 say aggravator B was met, that's not a unanimous verdict.
And it's interesting, too, one of the things that I believe it was Jeff Marcus, who's an assistant state attorney, had said was that it's about weight, not about counting. So it's not about the fact that, okay, there might be 6 aggravators and 3 mitigating circumstances, and this one outweighs the other based on how many there are. They have to look at, it's almost a little bit subjective, right? It's kind of like the pile of bad things versus the pile of things that could mitigate that.
Well, what Marcus was talking about was there's the other violent felony committed during the time that in and of itself is an aggravator. Now, for one victim, there are 16 of those other violent felonies, those other murders that are there. They all count for one aggravator, and that's what the defense was arguing. What Marcus was saying is, yes, I agree that's just one aggravator, but when you combine 16 of them, it weighs a lot more than just one. And the defense was saying, it doesn't matter how many there are, it still qualifies as only one part of the aggravator.
And of course, each side is trying to do what they can. The defense wants to do everything they can to spare the life of their client, so
Right.
they're going to argue as best as they can that way.
Exactly. I think so far, it's kind of jury charge conferences like this, the jury instructions conferences are notoriously tedious because every word matters to a certain degree, because this is what the jury's, this is the framework that the jury's going to have to use to decide their case. So everything becomes very important, and so you'll see the lawyers litigating over a word, out of 92 pages, which we've seen happen a couple of times so far.
Well, words matter, definitions matter, and I think also it is to be noted that a lot of people are watching this. This is a trial that a lot of people have been waiting for. They've been wanting to see this. They want to make sure that, I think both sides want to make sure that everything is done as best as possible, because, the public is watching.
Right, and so everybody's got to preserve their record. So you see a lot of the arguments from the defense, and they're doing that in order to preserve their record. So if it becomes a death verdict, that they have it available to argue on appeal. If you don't present it to the trial court first and give the trial court an opportunity to make a decision on it, then you can't complain later to the appellate court, in this case it'd be the Florida Supreme Court, that something went wrong.
Your arguments have to be on the record.
Right.
All right, looks like court is back, so let's take a listen.
much more clear for the jurors. So they say, okay, here's the rules for weighing the evidence, as opposed to just pages and pages of paragraph and paragraph and paragraphs.
I have no problem with that, Judge. Would you also want it, so then when we start with weighing the evidence, bold it, capitalize it, put it into the center of the,
Yeah,
and then above, would you want the page numbers?
yes. If there's more than one, I like there always to be the page, weighing the evidence, page 1 of 2, weighing the evidence, page 2 of 2.
Okay.
What is weighing the evidence? 7 point... Here we go, 3.9. So,
Yes, sir. Okay.
Mr. Sequel, would you pass this to Mr. Klinger and just, you can show it to your lawyers too. This is what I'm talking about. Just how it says it at the top of the page. You all have seen this 1,000 times. For whatever reason, in the penalty version of the instruction, it doesn't have it that way, and I prefer it that way for each of the subsections. Okay, so on page 9, mitigating circumstances, we'll start a new page for that instruction. Paragraph 1, under mitigating circumstances, is there any objection by either side?
And this is standard instruction, Judge.
No. You're talking about if you do unanimously find the existence.
I'm talking about what I assume is the standard instruction, first paragraph under page 9.
Yeah.
There is an objection?
No.
Okay. The second paragraph, it is the defendant's burden to prove that one or more mitigating circumstances exist. State, is this the standard instruction?
Yes, ma'am.
And defense, is there any objection?
So it's laid out in our version. It's red, crossed out. We put a proposed sentence in green, and I put in the footnote 10, the reason. So we don't need to rehash that. It's all in our.
All right, I'm going to read the standard instruction over the defense objection. Now, on page 10, among the mitigating circumstances you may consider are...
Your Honor, I originally had taken the list that Ms. Curtis had provided us in an email.
Okay.
But then, but mitigation is their thing, and so I took it back out until we decide exactly what they want and what the court allows.
Okay, so I'm going to refer to page 6 of the defense proposed instructions. It says, among the mitigating circumstances you may consider are, 1, Nikolas Cruz is a human being.
Your Honor, if I may be heard on that,
You may?
that the case law goes both ways on that. There's a Florida Supreme Court opinion that says that it is not a mitigator, but there's other Florida Supreme Court opinions that say it is a mitigator, but it is given no weight. There's no Florida Supreme Court opinion that gives it any weight. So in an abundance of caution, you can give it as a mitigator, but it will should not be given any weight.
So what should I tell them? This is a mitigator, but don't give it any
No,
weight?
you don't tell them that. It's for the jury to decide what weight to give it. And I'm sure the defense will be arguing that the defendant is a human being, and they can give it whatever weight they want and weigh it. They'll look at that in comparison against the 17.
Okay,
murder
so
victims.
you have no objection to me advising them that some of the mitigating circumstances are that the defendant is a human being?
There's really very few, Your Honor, that the state will be objecting to. We can make this a lot shorter if we just...
Sure, why don't you just tell me which
One
ones you're
I'll just
objecting
tell you. So the other one that the state is objecting to...
Wait, you're not objecting to one, though?
Not objecting to one.
Okay.
And we'll go all the way down the list until 14.
Okay.
Nikolas Cruz's birth mother died very shortly after her birth. And
died. Nikolas Cruz's birth mother died very shortly after he met her.
After he met her. And the state would object to that based upon the case of Beasley versus State 774 Southern 2nd 649 Florida 2000, which states, Your Honor, that a death of a family member that occurred after a homicide is not mitigating.
Is there any scenario where a mitigating circumstance could be something that arose after the crime was committed?
The defendant's conduct while he's in prison, while he's in jail, can be considered mitigating under Skipper.
Okay.
But there's a case from the Florida Supreme Court, and in contrast, because the impact of his father's death could not have affected Beasley at the time of the murder, when viewed in this context, the trial court did not err in failing to consider it as mitigation. And that's the Beasley case from the Florida Supreme Court, because they draw a distinction between what affected a defendant at the time of the murder versus after the murder.
Judge, we haven't had an opportunity to look at the case, but just based on what Ms. McCann just said, she said the court didn't err in not considering it. This is a jury that's making this decision, and if a jury finds that mitigating, then that's for the jurors to decide.
All right, I'm going to defer on that. I want to read the case. And what is the other one state that you're objecting to, or the other ones, the other factors?
And then going down the list, Your Honor, would be skipping to number 26K, where they say Nikolas Cruz was diagnosed with the following during his life. K, rule out autism. The state objects to that. It says rule out autism.
It's not a diagnosis.
It was not a diagnosis, and we object to that.
Defense?
Well, Judge, this did come up in a few of the records that we put in evidence. We could maybe think of a different way to phrase this, but I mean, this was...
A rule out is not a diagnosis.
I understand it's not a diagnosis, so we can move it and say that several providers believed he had symptoms consistent with autism or something like that. It's important because autism sometimes co-occurs with and is mistaken for fetal alcohol spectrum disorder, or the other way around. So we want to keep that in. If we want us to take it out of this section and put it in a different way, we can do that and send it.
All right, I don't think it's appropriate for being diagnosed with certain things, so I'm going to sustain the state's objection, take K out, and if you want to propose another paragraph where it may be relevant or fitting, you can let me know.
We can do that.
All right, what else, state?
The next one, Your Honor, would be number 38. Nikolas Cruz will be punished in prison and society will be protected. The state does not have a problem with saying that Nikolas Cruz will be punished in prison because there is case law that supports that a life sentence could be mitigating. But to say that society will be protected, society would be protected if he is executed as well, Your Honor. So the second part of that mitigator is not applicable.
Plus, aren't the other prisoners considered members of society?
Yes, and so, and we know what has happened when he has been incarcerated. So the state has no objection to the first part, that he will be punished in prison, but does object to the second part of the 38, the mitigator. Will be punished by being in prison. Maybe that's a better way to say it. I don't want to tell the defense how to phrase their mitigators, but
So you said there's case law that says mitigation can be the fact that if the defendant doesn't get the death penalty, that they will get life in prison?
yeah, there's a case, Ford v. State says that a life sentence, the fact that the defendant can have a life sentence could be considered as mitigation.
Okay, so Mrs. Curtis, you need to rephrase that so that it coincides with the case law, because,
Okay, we'll work on those two.
please.
And then there's,
I agree that if the case law says it's appropriate, but it's about society being protected, that part needs to come out. We don't know what's going to happen. There's people in prison. I mean, he attacked a prison guard, so I don't think you can make that kind of leap. But the fact that the alternative would be...
But Your Honor, just to be clear, it has nothing to do with making the cognitive leap that, he will be dangerous any place. It's just that the case law supports the proposition that a life sentence can be mitigating, and that's where the state wants to start and end its argument. It has nothing to do with future dangerousness, whether he's in prison or out of prison. We're strictly confining our argument to that a life sentence can be mitigating. And that is an important distinction for these proceedings.
Okay, so why don't you just put it exactly how the case law says you can put it,
all right, we'll take a look at that one.
please? And are those your only objections, State?
Yes, Your Honor.
Judge, and I forgot, we did want to add another one that we forgot about, which is that Nikolas Cruz pled guilty to all charges and took responsibility for the crime.
Okay, Mr. Klinger, are you able to cut and paste those?
I can send them to him. I don't know that he has a Word version of it, but
If you send that to me, I'll easily take them out and cut and paste them.
So you're going to find another more appropriate paragraph to include rule out autism or rephrase that one, and then you're going to rephrase the part about the defendant serving a life sentence or
yeah.
what have you in a you're going to rephrase that. Okay.
Okay, so Judge, I do have some, a proposal for the autism one. Multiple mental health providers believe Nikolas Cruz had autism or autistic features. We haven't done the other one, but
And where do you propose to put that?
we can put that, just insert it somewhere.
Well, Judge, I think we have to say that it was ruled out. I mean, I mean, the mitigators have to be reasonable. They just can't throw things out.
I don't know where it was ruled out.
Well, he wasn't ever diagnosed with autism.
Right, well, the mitigator says multiple mental health providers believe that he had autism or autistic features.
That's not true.
Not that he did.
There's no evidence of that. There's no evidence that multiple found that he had autism or autism features.
I remember, like, offhanded, I remember some things being testified to in maybe school records that perhaps he needs to be tested for autism, but I don't remember any direct evidence. And maybe I just don't remember. Just remind me, who testified?
Your Honor, may I?
Yes?
So, if you remember, Dr. Weisblack made an indication that Nikolas needed to be further evaluated for autism or pervasive developmental disorder. Also heard testimony from Dr. Kravitz. He was the first doctor that the defense put on, that he believed that Nikolas's lack of eye contact and his limitations in social skills was consistent with a child that had autistic features. And Dr. Negan consistently said throughout his report, initially there was a rule out of the PPD, and then what happened was in 2013, the DSM changed and got rid of PPD, but his diagnosis was consistently issues with social skills and communication, which was also included in the letter that he sent to the school board. He put has features of PPD, and then in parentheses he said social skills.
What is PPD?
Pervasive developmental disorder. Before they had the spectrum, and then in 2013 they removed that from the DSM. And Denny also agreed and provided testimony that Nikolas had features that were consistent with autism.
Your Honor, what Ms. McNeil said is a lot of people suspected he might have autism and looked into it. That's it. That's all is what Ms. McNeil just said. There is no diagnosis of autism. They all the people that she's mentioning, they just said maybe. And that's not a mitigator. That I suspect, he might have had this or a feature of it, but like Dr. Denny said, he didn't have it. Are there features of it? Yeah, there was one or two things, but that's not autism. And that's what everyone said. No one diagnosed him as autistic.
And then we would ask, Judge, if you were not inclined to give that exact language, that you include that pervasive developmental disorder was never ruled out. And was included by multiple mental health providers, including individuals from Henderson. The state's own expert would include that in his evaluation. And then Dr. Negan, Dr. Kravitz, Dr. Weisblatt, all of those individuals said that. Sorry.
It's in out there already. You already have it.
If it's in there, then that's fine. I mean, we're not going to waive the issue.
It says pervasive developmental disorder is 26G. So they already have what they're asking for. There was no diagnosis of autism, and they admit that there wasn't, because the most they have is rule out, and that's not a diagnosis.
And that's not what we're asking to say. We're asking to say that multiple mental health providers believe that he had autism or autistic features. We're not saying he was diagnosed with it. We're saying...
But that's not true.
It is true.
You're telling me that multiple doctors testify that he has autism or autistic features? Who?
Not testified. Some of them testified, but it's in records that we put into evidence. The Social Security records, we did not have a witness testify, but we put those in evidence. Dr. Negan. Right.
It does not say he had autism. Ms. Curtis keeps saying that. There's nothing in any record that says he had autism. Is there a feature?
All right, a rule out is not a diagnosis.
I understand that, but what we're asking for the mitigator to say is, and we can leave out the autism, we can just say multiple mental health providers believe Nikolas Cruz had autistic features. We're not asking to say he was diagnosed with it. We're asking the mitigator to say that he had, that many of his providers believed he had autistic features, because then that's consistent with our argument that people with FASD have autistic features or are often misdiagnosed with that.
He wasn't misdiagnosed with autism. The argument doesn't make any sense. They're saying they're using it so that he was misdiagnosed with autism. He wasn't. He was never diagnosed with autism.
No, but the fact
They can say that the fact that he didn't look at me directly, that's an autistic feature. But it's not autism. It's an autistic feature. If there's a lot of other features, then it would be autism. Otherwise, it's just he didn't look at
And
me.
you can't outgrow autism, if I'm not mistaken. Can you? Because the doctors currently believe your client does not have autism. Correct? The
Right.
current evaluations say he's not autistic.
there's also an indication of autism, ADHD in the.
But I'm asking you, do the current doctors who evaluated him for hours and hours and hours, do any of them believe or did any of them testify that he has autism?
No one testified that he has.
Okay,
autism.
and you can't outgrow autism, but yet you want me to instruct the jury that a mitigator is that he has autistic features, even though all of the doctors from both sides are in agreement that he's not autistic.
No, I'm not asking you to instruct the jury that as a mitigator he had autistic features. What we're asking for is, and even the state's doctor does agree that he has autistic features. Multiple mental health providers believed Nikolas Cruz has autistic features.
But he doesn't have
That's true.
autism.
That's, okay, but we're not asking you to tell them that he has autism. We're asking you to tell them that
What you're asking is clearly misleading. You're asking me to advise them that a mitigator is that he has features of autism, yet he does not have autism.
No, that his mental health providers believed that he had features consistent with autism.
You can have features consistent with a lot of things. If you don't have the actual thing, it's not probative.
Well, Judge, the standard
It's
here
misleading.
is very low in terms of providing mitigating evidence. So.
Which is why I'm giving them 36 or 40 paragraphs of all different things, including deficits in developmentally delayed, severe phonological delay, memory deficits, motor function delays, neurological impairments, social skill impairments, adaptive functioning deficits, executive functioning deficits, central nervous system abnormalities, independent functioning deficits, cognitive deficits, intellectual deficits, and so on and so forth. To suggest that he has autism when the testimony is in direct conflict of that is misleading, and I'm not going to do it. So that request is denied. All right, now when okay, so after you insert you make the changes, you're going to make the changes to paragraph 38. I've ruled on paragraph 26K. I'm deferring on paragraph 14. But other than that, we're going to go to the next paragraph where your decision regarding the appropriate sentence should be based upon proven aggravating factors. I see that the defense is suggesting taking out a few words to the standard language. Other than that, is there any objection to the standard instruction? Other than what you've written in green. And
No, I just wanted to correct, though, that in that paragraph, that short paragraph, the aggravating factors proven by the state beyond reasonable doubt, that should have been in green, but no other.
What should have been in green?
Well, so the standard instruction says your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances. But in my version, I took out proven in red, but then I forgot to put proven by the state beyond a reasonable doubt. We just wanted to reiterate the standard of proof again, and I didn't put that in green. That was my error.
Okay, I understand. Thank you for pointing that out. I'm going to give the standard instruction on that paragraph over the defense objection. The following paragraph, the next step in the process state, is your version the standard instruction?
Yes, ma'am.
And defense, you're suggesting adding a few sentences, the state has proven beyond a reasonable doubt, and you may always consider mercy in making determination?
Yes, ma'am.
And you agree those are not part of the standard instruction?
Yes, ma'am.
All right, I'm going to give the standard instruction over the defense request. The next paragraph state, is that the standard instruction once each juror has waived the proven factors?
Yes, ma'am.
And the defense has added or suggested or is arguing for additional language in green that's beyond the standard instruction. Is that correct?
Yes, Judge, it's just to reiterate the standard of proof.
Okay, I'm going to read the standard instruction as to that paragraph.
I did make a change in the next paragraph, Judge.
Rather than, it looks like rather than saying you will be provided with a form, you're asking me to tell them you will be provided with 17 forms to reflect your findings and decision regarding the appropriate sentence for each count of first-degree murder.
Yes, ma'am.
Defense, is there any objection to clarifying that?
No.
Should we put 17 verdict forms instead of forms?
No. The standard instruction says form.
With
We would
a
just
form.
ask for the underlining and the italics.
Yep, take off the underline and the italicize. Okay, and then you'll take off the footnote number as well as the actual footnote. Then the next paragraph. Okay, so I'm trying to figure out where we should stop the designation of mitigating circumstances.
According to the Florida Supreme Court's instructions, the weighing of it begins with the next paragraph, when considering...
Right, but there's a couple of paragraphs that fall on the state's proposed 10 and 11, which I don't think are part of mitigating circumstances. In fact,
The weighing process? So,
I think after the, so we're going to, Ms. Curtis, we're going to separate mitigation, the mitigating circumstances, separately where it defines mitigating circumstances, just like aggravating factors.
Okay.
It looks to me that after the mitigating circumstances are listed, that we should start a new page.
Okay.
Do you agree that your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances? I don't think that's part of the definition of mitigating circumstances.
No, that's fine.
Okay, so let's start a new page. Right there. On page 10. And then on the top of page 12, I want to add weighing the evidence in bold, like I showed you. Now, is there any objection to any of the paragraphs under weighing the evidence? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Is either side asking for that paragraph?
Yes, Your Honor.
Okay. How about, had any pressure or threat been used against the witness that affected the truth of the witness's testimony?
Yeah,
Yes?
yes, we will have.
And has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? I don't remember.
Well, we did have some witnesses.
Felony conviction.
Okay. How about a general reputation for dishonesty or truthfulness? Paragraph 10.
I don't think there was any evidence of that.
Is either side asking for paragraph 10?
No.
All right, so we'll take paragraph 10 out. And if you would please state, just put weighing the evidence page 1 of 2, weighing the evidence page 2 of 2, please.
Yeah.
Obviously, defense, you're asking for the paragraph that says the defendant exercised a fundamental right, correct?
Yeah.
Now, on the top of page 14, if you could please put bold in the middle, rules for deliberation. And you took out number 5 about the juries not to discuss any questions that a juror wrote that was or was not asked in court. You all took that out because we didn't do that in this case.
I don't see it in here.
I just want to make sure.
Steve,
I'm sorry, which one was that, Your Honor? You asked about?
we took out the notes.
Right.
Yes, Your
I
Honor.
didn't allow the jurors to ask questions. I just want to make sure that was taken out.
Yeah, I don't see it in here.
Right. Oh, yeah, that was taken out.
Okay, and then on page 14, where it says in just a few moments, if you can start a new page and put submitting case to jurors.
Submitting the case to the jury.
Or just maybe just start a new page.
Okay.
Judge, if we could just go back, in our submission, Judge, we did red strike through on some of these rules. There's detailed arguments in the footnotes for that and for the ones that we wanted to add, all of them supported by U.S. Supreme Court case law for every one of these rules. And so those are the requests that we would be asking to add to the rules for deliberation. It's on pages 10 and 11 of our submission, and 12, I'm sorry.
All right, under rules for deliberation, I'm going to give the standard instruction. Now, where it says in just a few moments you'll be taken to the jury room,
And paragraph that, I mean, I put that in there, that's, you know, certainly however the court wants to handle the verdict forms. That's not found in the standard instructions.
what are you talking about?
Well, we went to the new page, right, for submitting the case?
A
Or
new
did you
page
just say do a new page?
only because if both sides are going to take 2 hours for closing, we're going to end up with some extra time. So I'm going to read most of the instructions tomorrow when you're finished. And I don't want to say in just a few moments you're going to be taken to the jury room. That I'll probably read on
I see.
Wednesday
Okay.
morning.
Oh, so you're going to read the instructions up to that point? on
Or
Tuesday?
about to that point. I'm not sure exactly. I want to find a logical place to stop. Of course, I'm not going to say in just a few moments.
Oh, okay.
Mr. Klinger, what did you say you added?
Your decision must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows.
This is a standard instruction.
But not, it's not in the Florida Supreme Court's penalty-based instruction, I don't believe. But I think you're right that it's included in the regular jury instructions.
Right, but it's kind of repetitive. On page 11, it already says you will be provided 17 forms to reflect your findings. So I just don't think it's really necessary to have that in there.
Well, I think it informs them that, you have, they have to be, every form has to be signed and dated. They have to go through each one. And I think it tells them that at least they're going to be printed for the convenience, but they'll know they have to go to every form. And it's up to the court. They're rather lengthy verdict forms. So it would be up to you, Jerry, if you want to read the version that applies to those counts that only have 5 aggravators, and then the version that applies to the count that has 7 aggravators.
It's 3.13, submitting the case to the jury. So you're saying that the death penalty standard instructions don't include 3.13. It says in just a few moments you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and bring the verdict forms back to the courtroom when you return. It also indicates that this instruction or a version of this instruction needs to be included, because these are things that they need to know. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. Then it also says during trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations, and then it indicates that you either tell them that all of the exhibits or some will be sent into the jury room with you when you begin your deliberations. And then that's usually where I put except, and then I put what's not going to be sent back, and I tell them if they want to examine those specific exhibits that are not going to be sent back, that they should let me know, and we will make that exhibit available to them to view in court.
It's in the states.
It is.
Yeah, all of that is there, Judge. It was just the verdict form that I was sort of leaving up to how the court wanted to handle that. The rest of it, you'll find that it's all there, although we did add some things into the, what would go back to the jury room and not go back, but of course, the court, whatever the court's preference is on that is fine.
So the only part that you added is your decision must be in writing, and for your convenience, the necessary verdict forms have been prepared for you.
Next page, too.
Yeah, and then the very page 16, the bottom of 15, the top of 16, change some of the wording there.
Okay, is there any objection to the way the state has spelled out page 14, 15, and 16?
Judge, we're asking that that we, instead of reading this, that we say, if you wish to see any exhibits, please request that in writing. There are boxes and boxes and boxes, and there's 20 of them. Or no, there will only be 12, but it's 12 people, but a huge amount. I mean, you either have to send it all back or none of it. I mean, you can't
Judge, we'd
send some and
object,
not others.
Go ahead.
we'd object to that in that the evidence goes back. Our only restriction should be guns or ammunition, not both together.
Okay, is there a way, I think both sides had or we can copy what the clerk has written, an exhibit list so that they can okay, I've been thinking about this a couple days. If there's 500 state exhibits, let's just say, how are we going to, shouldn't they be in some kind of order so they can find, like 1 through 100, 101 through 199, or whatever it is? And the same for the defense?
I think they are in order.
I'm reading one objection.
But
We have no objection to giving a list, the clerk's list with them, but they should, all the evidence should go back. Otherwise, someone's going to have to remember a piece of evidence, identify it before they can get it. That's not how it should work.
We don't have an objection as long as they're given all of it, except for not the gun and the ammunition together and no biohazardous material. That's fine as long as they have all of it, all those boxes of records and evidence, and we can provide a list also.
what biohazardous material was sent back? I'd rather tell them exactly what it is. Like DNA swabs?
Did we introduce DNA swabs? Yeah. There might, I guess there's DNA swabs.
But they're all packaged.
They are all packaged, yes. They
And
should.
they're in like they're not just packaged, aren't they in sealed bags? I don't remember. Is it, okay, so is it just DNA swabs?
That's all I can think of.
That would probably be the only thing, and I'm not even sure if we're going to enter them and then maybe we'll.
Okay, I would just ask that you go back through and list specifically what won't be sent back. Ammunitions and weapons will not be sent.
Yeah. They could have the ammunition or the gun and just switch it. The easiest is to just give them the gun first and then the ammunition if they want it afterwards. It doesn't matter.
Okay, so then I would like to say the firearm will be sent back and explain that it is, what is the word? It is
Made safe.
Secured.
so that it cannot be discharged. However, we will not be sending back the ammunition unless, if you want to see the ammunition, you need to make that request in writing. And then rather than
Give us back the gun.
Excuse me?
And then they'll give us back the gun.
Okay, and then rather than no biohazardous material, I'd rather that you list those things, please, whatever they are. You know, items A, B, C, and D will not be sent back into the jury room. If you wish to examine those exhibits, please put that request in writing. And then now, Ian, don't we have a way for them to listen to digital recordings? We have
There's a system in there.
okay, so perhaps you all should go look at the system that we have. It's blank, so it doesn't have any,
He has no access to the internet, nothing, all they can do is put it up and play whatever.
Okay, we have a system in the jury room that was put in by court administration when the new courthouse was built, has no internet access or access to anything other than it will play a digital recording via a zip drive. Is there any digital evidence that is on something other than a zip drive, like a DVD or a CD? I don't.
Yeah, there are discs.
I'm sorry?
There are discs.
You can? I think that you should pick one lawyer from each side to go back there with Ian to test this stuff out, to make sure it's simple and no further instructions are needed.
Judge, could we also have an agreement from both sides that Ian can go back with the jury initially just to show them how to use the equipment?
Sure, I think that's a good idea. And we can do it before their deliberations begin, before the door is closed, before,
Yeah, he wouldn't listen to anything.
Correct.
Just show them how to use it.
Is there any objection?
No.
No?
For Ian to go back with them?
Before they begin their
close the door?
deliberations, to give them a brief tutorial on how to use the equipment. I'm assuming out of 12, there's probably one that's pretty savvy with computers, just because usually more than 1 out of 12 are, but who knows? I think that's a good idea. So there's no objection from either side, correct?
There's no objection from the defense.
State, no objection.
No objection.
Okay. So we're going to... Is there any objection to a list? Okay, so my question is this. If they want to hear, let's just say, one of the, recording 3 that was played during Dr. I don't remember his name, the second to the last expert. What was it? And I'm trying to pick something.
Dr. Denny. Dr. Denny, and we played some clips from the...
Who was the one before that?
Dr. Scott.
Dr. Scott. Let's say they want to hear clip number 3 from Dr. Scott. And there's all this evidence sitting there. How are they going to find that? I'm trying to pick something that's not fresh in everyone's memory so that you all see where I'm going here.
Well, will we give them a list of the items and evidence?
Well, that's my question. We need to do something because there's so many things from both sides that if they come up with, I want to hear this or that, there should be a starting point. Can you see your evidence list, please? I am open to suggestions. I don't know if this list is going to be enough. If you all want to take a look at it. Sure.
Do you want me to email them to everybody, including yourself down there, and you can see my list and see if that seems to
Are
be
we on the
easier?
record? No, it doesn't have to be. Why don't we take a 10-minute recess?
Okay, so they are taking a 10-minute recess. They're going sort of paragraph by paragraph, line by line in these jury instructions. They're getting there. It's 92 pages of instructions, but many of it are the forms for the jury members.
Yeah, I think 68 or 70 pages are the verdict forms. What they're talking about now is the logistics of dealing with the evidence that was presented and admitted into evidence, because the jury has the right to have that back with them so they can review it while they're in the middle of their deliberations. But I think the state admitted close to 500 pieces. I lost count on the defense. So there's quite a large amount of, it's probably going to be banker's box after banker's box after banker's box full of things that the jury can go through. And what they're trying to figure out now is, if the jury says, oh, I want to see this particular piece of information, how do they find it in all of that?
How do they catalog it? And not only are there physical pieces of evidence, of course, the big ticket items like the murder weapon and some of the things that the defendant was wearing, but also there are those pieces of video which may prove to be interesting and crucial for those jurors to re-watch. They had the opportunity to see the videos, many different videos in the courtroom, but they may want a second look. So yeah, how do you go through all of that and say, well, remember that one where he was sitting with that one psychologist or that one psychiatrist? Yeah, how do you
with this amount of data, it's going to be difficult, I think, and so they're trying to figure out the logistics of that. That being said, they kind of knew that this was going to be a logistical nightmare for the last few weeks. I'm surprised it hasn't been hashed out yet, but that's where we are. The state was saying that they're going to send somebody back with the jury just so they can show them how to work the technology in order so they could see those videotapes and see those video clips, which I'm sure they're going to want to see again. Some of the documentary evidence, maybe not so much, but the judge said that the gun's going to go back, but if they want to see the ammunition, they have to give the gun back and get the ammunition, because they don't want the ammunition in the gun, for obvious safety reasons. Even though the gun's been rendered, safe, they don't want the ammunition and the weapon in the same room at the same time.
Lots of pieces of evidence, lots of witnesses, lots to consider, and of course this 92-page jury form that they're hashing out right now. They are taking a quick 10-minute break to get some things together. We will too, and we'll be back as soon as court is back in session. Welcome back. This is the sentencing of the Parkland school shooter. I'm Janine Stanwood with our legal analyst, Craig Tricino, with the University of Miami. A hearing before the jury will listen to closings and then their instructions.
Right. And we're going through the end of the instructions here, and we're trying to figure out the logistics of the evidence that the jury's going to see.
And there's a lot of it.
First, but one after Perry, in that period afterwards, the Florida Supreme Court then changed the jury instructions and no longer required that the mitigation be listed in the verdict form. That change was made by the Florida Supreme Court, I believe, in 2018, and they have not deviated from that course. And as of now, all they require is for Section C to read one or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence, yes or no. And they do not require any other list.
I can't hear you. Would you speak up just a little bit, please?
I'm sorry. If you look at number C in the verdict form, probably the third page,
Okay.
where it says mitigating circumstances.
Okay.
Prior to 2018 and after first, you would have to list the individual mitigators and what the votes were on the mitigation. That was taken out by the Florida Supreme Court. And the only thing that they've asked to put in now in the standard instructions is what you see on C, where it says mitigating circumstances, one or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. And it's been that way for the last 4 years.
Okay, I am going to use the standard verdict form. However, if these pages get mixed up in the jury room, I don't know how they would put them back together. I would like to indicate somewhere, maybe it can be, I think there's a way you can put right next to the page number at the bottom, count one, Luke Hoyer. That should say that on each page for each of the victims, so that, well, I see that his name is written in some of the paragraphs, like on page 2, but do you all see what I mean?
Yeah, no, that's...
There are 17 victims. If the pages
we can fix that.
get mixed up, I don't know that, I think only page 1 and 2 say the specific victim's name. Do you see what I'm saying?
Yes, I know. I understand what you're saying. We can fix that. That's not a problem. So the name will be...
If you can put the count, just count 1, Luke Hoyer. Count 2, Martin Duque. But make sure it says it on each page so that, like I said, if they get mixed up,
No problem.
they can keep them together. Please. Is there any objection?
No.
You see what I'm saying? Only the first 2 pages list the specific count. So I just imagine myself going through all of these things, and if some of the pages are not kept in the exact order, that way they can refer to them properly.
And then even though it's not required any longer, we are requesting that the mitigating circumstances, we can maybe we're asking the mitigating circumstances be listed on the verdict forms. And we're asking that each one be listed with a vote or the number of how many jurors found it and did not find it. And the reason is that once a mitigating circumstance has been established, the jurors must consider it. There's no direction as to the weight they have to give it, but they must at least consider, and this would reflect that they did consider it even if they didn't give it weight.
And that was the way it was for a short period of time after first, until the Florida Supreme Court decided But it no longer needed to be that way, and they changed the standard instruction to no longer include having to list the mitigator.
And the standard instruction is what you have proposed?
Yes, ma'am.
Other than the change that I want that the count be listed on each page so that the verdict forms do not get mixed up.
Yes, that's correct.
All right, I'm going to give the standard verdict, use the standard verdict form as recommended by the Florida Supreme Court, or as used by the Florida Supreme Court.
Your Honor, did you intend to read every verdict form separately? I don't think you need to. I think you can do it in two groups. There's 14 of the verdict forms read identically, except as to names, it's all the same with the aggravators. And then 9, 11, and 12 could be the second group.
Okay, so what I will do then is I'll read one verdict form for the first group, which begins with Luke Hoyer, and I will say this verdict form applies to victims, and I will read the names of the victims and the counts that it applies to rather than reading it 14 times. Does that make sense?
Yes.
And then as to the 3 individuals who I would call adults or employees of the school, I will read their specific verdict form, and I will indicate that this specific verdict form is identical for the 3 victims, and I will list those victims and their counts. Okay.
Your Honor, just one more thing to the record regarding jury instructions from
Sure.
the defense, please. Just want the record to reflect that the state had requested alterations to the standard instructions 10 times, and those were all granted, and the defense in 14 areas of standard instructions asked for alterations, and they were all denied.
Okay, moving on to the motions. The motion eliminate to prohibit the state from mischaracterizing trial testimony during closing argument. Is there anything you want to add to your written motion, defense?
Your Honor, I just wanted to highlight some things, if I may.
Sure.
Please. So we are asking that Your Honor prohibit the state from describing Mr. Cruz as a sexual predator or referring to any of his past conduct as sexual molestation. As you recall, and we've talked about it many times, there was perpetuated testimony by defense witness Danae Brown where she talked about the inappropriate touching that happened with her daughter. And then there was a second witness.
State, are you in agreement to use the word sexual predator?
Yes, Judge, we will use inappropriate touching. That was the first.
All right, that's granted.
Thank you.
Is there anything else in this motion? I think that's all it
That was all
addressed.
Thank you.
So there's 2 motions left. Defense, corrected motion to preclude the death penalty based on prosecutorial misconduct in attempting to interfere with defense presentation of mitigation. Defense, is there anything you wanted to add to your written motion?
No, Judge, it's all in the written motion.
State, is there anything that you wanted to argue, or I don't think you filed a written response, but is there anything you wanted to?
We did not, Judge. There are some things I'd like to put on the record.
Okay.
With regard to Jack, I think it's Vese, V-E-S-E, I'm sure the court remembers this issue had already been litigated and it was actually in front of the jury. The issue of the phone call that took place.
the morning of September 1st with Mr. Marcus and Christopher Whitlock, which is Mr. Vesey's attorney. As the court is aware, it's entirely proper for a lawyer to talk to a witness before they are called to testify. The fact that Mr. Vesey got the impression that, and it's his subjective interpretation, that somebody didn't want him to testify, that was not the subject of the call. To the contrary, the subject was, what are you going to testify to? And it doesn't even appear that Mr. Marcus was on the call during that time. On cross-examination, which is conveniently omitted from the defense's motion, and this is on the trial transcript, page 7889. This is September 1st, the cross-examination of Mr. Vesey. I asked him, you're aware that it's permissible for lawyers to speak with witnesses, right? He answers yes. I asked, okay, and you testified that you were concerned this morning, or that your testimony, or whoever was on the phone, that your testimony would negatively affect individuals within the Broward County School District. His answer, yes. I asked, but that person was just Mr. Whitlock, correct? And he answered that I was worried about Mr. Whitlock. Question, Mr. Whitlock was worried. He was the one concerned about your testimony. Answer, he voiced that. Yes, he did. He's the one that voiced that. Okay, not Mr. Marcus. The answer, no. So the only person that could have made him feel nervous about his testimony would have been Mr. Whitlock, and it wouldn't have been anything that Mr. Marcus questioned him about. So I just reiterate that it's entirely proper for a lawyer to talk to a witness before their testimony. Certainly doesn't arise to the level of prosecutorial misconduct. And lastly, we were getting lists, as Your Honor knows, after 5 p.m. the night before witnesses were called in the mitigation case. So the only appropriate time for Mr. Marcus to have the conversation would have been that morning before he testified. So there's absolutely no prejudice established with regard to that Mr. Vesey's testimony. As to Dr. Andrew Ackerman, and I just want to let the court know, I plan on reading from the statement that had been previously subject matter of it being sealed when we filed a notice to the court after the Daubert hearing was canceled, and it was in part, this statement became part of that issue. Dr. Andrew Ackerman was a radiologist that was, or excuse me, a neuroradiologist who is hired by Acumen, which is the agency that does MRIs and PET scans and so on and so forth. On the day that the defendant got his MRI, which was November 30th, 2021, Dr. Ackerman was randomly assigned to interpret it. So first and foremost, in their motion, in paragraph 14, the defense claims that this phone call to Dr. Ackerman with a defense hired expert. That's really disingenuous because they didn't hire Dr. Ackerman. Dr. Ackerman was on this by pure chance. So, and again, this is in November. Then in March of 2022, it turns out that their defense hired expert, Dr. Richard Adler, called Dr. Ackerman and said, hey, I have all these different reports, a brain triage report and DTI reports. You should take a look at them. And by the way, I'm Dr. Adler, a renowned scientist in fetal alcohol spectrum disorder. Dr. Ackerman thought it was rather strange. Meanwhile, we were not made aware of this phone call or any of this communication. During that time, Dr. Ackerman was not listed as a defense witness, and my office was making attempts to speak with him. On June 9th, and because of that, the defense filed him as a witness because they wanted to be part of the deposition. After he was listed on June 9th, our office began trying to coordinate with the defense to take his deposition, and they tried to stop it by claiming there was a non-disclosure agreement. That has nothing to do with us. That has to do with Dr. Ackerman and the defense. And the MRI report had been disclosed months and months before. So you can't hide behind a non-disclosure agreement because you don't want to participate in the subpoena. And then fast forward to June 22nd, 2022, we get a letter from Dr. Ackerman, and I will have it as an exhibit. And I would just like to read it into the record. This letter is to state that at the time of my original report, I was hardly given any information on the patient. In fact, I later learned that there were additional sequences performed that were never provided to me. Most times it is typical that we receive incomplete information from imaging centers, and as a result, in this case, my original report was based only on the information I had at the time. Although my report indicated that the original neuroquat sequences showed no visible significant abnormalities, that report was written without the benefit of having access to quantitative DTI and NQ data, nor the brain triage atrophy report. These missing sequences were given to me at a later date, and I was asked to amend my findings. At that point, I no longer felt comfortable with providing the quality of report I am accustomed to providing. The missing information has tainted my original assessment and biased me from doing any further objective analysis. This statement was the product of Dr. Adler calling him and trying to get him to change his report. And we learned that at Dr. Adler's depo, which was, I believe, August 5th, 2022. And after we took the deposition from Dr. Adler, where we learned that he had in fact made this contact and had these emails, we set Dr. Ackerman for a pretrial conference on August 11th, 2022. The defense removed Dr. Ackerman from the witness list on August 5th, 2022. So he was no longer a listed witness on August 11th, 2022 when we took the statement from him. The accusations that they made in their motion, paragraph 16, for example, on August 11, 2022, the date of the pretrial conference, defense counsel advised the state that Dr. Ackerman had requested that the defense counsel attend the pretrial conference. Not true. If you look at the statement, Dr. Ackerman's statement from August 11, 2022, on page 24 of that statement, I asked Dr. Ackerman, okay, all right, have you been in contact with Dr. Adler at all since the last conversation? He says, I have not had contact with anyone. Question, okay, anyone from the defense team? Answer, anyone from the defense? Right. So obviously there's been no conversation between the defense and Dr. Ackerman before he was prepared to give the statement to the state on August 11, 2022. As far as the paragraph 19, it suggests that there were multiple conversations between Dr. Ackerman and my office. Again, that's untrue. The only conversation that went back and forth, it wasn't conversation, it was scheduling. It was emails trying to get my office and Dr. Ackerman's office on board for a date that was convenient for them for a statement. I had never met, nor had anyone from my office met or spoke to Dr. Ackerman prior to August 11, 2022. I don't understand what even anything in paragraph 20 has to do with the motion, but what it doesn't contain is exactly what went on during that statement. And I'd again refer back to the statement that Dr. Ackerman gave. And I asked him, okay, so this study, this is page 9. Okay, so this study was done on November 30th, 2021. And when you got the image, were you also provided the neuroquat sequences? And Dr. Ackerman responded, there we go. Sorry, we had a little bit of a delay. I got also, I'm not moving anywhere. But anyway, having said that, just to finish the story, this is where it gets really annoying and frustrating, is that I always ask for as much history as possible. And the more history I have, or if I have any prior
Slow down,
studies-
just a little, please.
Those are always a radiologist's best friend. And the more information I have, the better assessment I could get. Out of nowhere, I get this phone call from this gentleman from Seattle. Okay, and he's supposed to be some famous neuro-schmuro, whatever, big name in neuroscience. I've never heard of him, but that doesn't mean anything. I mean, he's like practicing in the Northwest. So this is why I felt a little bizarre, because not only did he provide me with the quantitative data, which it's like, why the hell did you get that, and why didn't I get this in the first place? But he was pointing towards figures in the quantitative data that would show me why they were subtle differences. And I'm thinking, is this guy trying to talk me into changing my opinion? So that's why I'm like, all right, this is too much. I just want out of this. Like, I got half a study. I interpreted it the way I could. Now I'm getting all this quantitative data. Plus he's the one that told me, like, all this family history, like fetal alcohol syndrome and all this other nonsense. Why didn't I get that in the first place? And I continue on again, page 23 of that statement. Okay, and to be, you've said this, you felt that Dr. Adler was trying to get you to change your report. Answer, well, I don't want to throw him under the bus. My question, put it in your own words then. His answer, essentially, I felt that once I realized...
Ms. Giappone, just if you could, you're like over 300 words a minute. Just a little bit slower, please.
Essentially, I felt like once I realized what was going on, I felt like the defense was trying to push me in a certain direction. So clearly the state wasn't doing anything improper by questioning this witness when it received information that one of the defense experts had called and tried to get Dr. Ackerman to change his report. Being upset that you weren't invited to our pretrial conference doesn't give you a right to make accusations of prosecutorial misconduct. Lastly, Judge, I just point out that the case law in the motion is not applicable whatsoever. The Dent's case, the alleged interference was a Department of Corrections investigator who promised a defense witness that he'd get parole if he refused to testify. And in the Hammond case, this is an FBI agent who approached a defense witness while the court was in recess and basically threatened him. This witness had an indictment pending in Colorado. He said Colorado's going to go real bad for you if you continue to testify. So these facts have nothing to do with what's going on here. None of this was preserved, and these witnesses didn't testify. So there is no prejudice. They also didn't file a motion to quash the subpoena, which they could have done. They knew we were going to speak to Dr. Ackerman on the 11th, and if they wanted to stop it, they had a remedy to do so, and they chose not to. So we're allowed to talk to witnesses. There's no prosecutorial misconduct here. There's nothing improper that the defense or the state did. So I would ask that this motion be denied. I wanted to just make a record, and I would like to move in the documents that I referenced to. I have them marked as states 26R, 26S, and 26T, so that the record is complete.
You want those as court exhibits, so no?
Yes.
You're not going to go to the jury,
Yes,
obviously?
correct. Yes.
So, what? Wait, when the lawyers were up here looking at,
8, 9, and 10.
I just got blamed for something. Is going to be received as Court Exhibit 8, 26S 9, and 26T is 10.
Judge, may I respond briefly?
I asked you if you had anything to add to your pleadings, and you said no.
Well, no, I just have a response to...
Okay.
Okay, so first of all, and I don't understand why the state keeps saying this, because Mr. Vesey made it perfectly clear. Christopher Whitelock is not his attorney. He's a friend of his. And in fact, Mr. Vesey testified he's been retired from the school district for 6 years. So there shouldn't be any confusion. Mr. Whitelock is not his attorney. And I would find it hard to believe that he would represent that he was his attorney. Second of all, it doesn't really matter whether it was Mr. Whitelock or Mr. Marcus that was saying things to Jack Vesey like, what you say could have implications for the district or implications for people that are friends of yours.
How can you say that it doesn't make a difference? If Mr. Marcus wasn't even on the phone when that was said, how can you possibly say that doesn't make a difference?
Well, I don't know that there's evidence that he wasn't on the phone.
Mr. Marcus said he wasn't on the phone.
I understand that, but what Mr. Vesey said is they were concerned about the testimony that I was going to give and how it might implicate other people is probably the best way I can put it. He didn't say Mr. Marcus left the call, so at best, we have Mr. Marcus standing by while another member of the Florida Bar is trying to pressure a witness into taming his testimony.
I don't disagree with that, but what Chris Whitelock said, for whatever reason, what does that have to do with Mr. Marcus?
Because if he's on the phone and that's going on...
He said he wasn't on the phone, and your witness doesn't know.
Mr. Vesey said that they were on the phone. He said that they were both on the phone.
He did not say that.
I'm reading the transcript. They were concerned about the testimony that I was going to give.
But
and how it might implicate other people.
When he was asked who said those things, he said Chris Whitelock said them.
Right.
And then Mr. Marcus said he wasn't on the phone when that happened. So what you're asking me to do is presume that Mr. Marcus is lying and that he was in cahoots with some school board lawyer who, for whatever reason, said something to a witness that was, I don't know if it was inappropriate or not, because I don't know exactly what was said.
Well, I don't see what motivation Mr. Vesey would have to make this up. He said he got a call.
I'm not saying he made it up, but what he said was Chris Whitelock said X, Y, and Z to me. Mr. Marcus is representing that he wasn't on the phone when those things were said. So what does this have to do with Mr. Marcus?
Because Mr. Vesey testified otherwise and said that Mr. Marcus was on the phone. And if Mr. Marcus hears another member of the Florida Bar trying to pressure a witness into changing his testimony or not testifying, then he should have immediately terminated the conversation and reported it to all of us right away, and that never happened. And that's the best case scenario, that he listened while it happened.
He said he wasn't on the phone. Did the gentleman not call the witness before he spoke to Mr. Marcus? Isn't that what happened?
Yes.
Mr. Whitelock called the witness and then conference called Mr. Marcus.
At the request of Mr. Marcus. Why would Mr. Whitelock call him without being requested to do so?
Of course, he said he asked him. He wanted to speak to a witness before he testified. There's nothing wrong with that. In fact, the rules say otherwise. So you're going from one extreme to another. I'm not going to make a judgment as to whether or not Chris Whitelock said something that was inappropriate, because really that's none of my business. But if Mr. Marcus wasn't even on the phone for that part of the conversation, you want me to throw out the state's death penalty case because of something that another lawyer did?
Yes. We're asking that this court preclude the state from seeking death because Mr. Marcus was on the phone, and I understand the court is saying no, but Mr. Vesey testified otherwise. They were concerned about the testimony that I was going to give and how it might implicate other people is the best way that I can put it. He named him by name, Judge. He's indicating Mr. Marcus is on the phone, and even if Mr. Marcus didn't make these statements to him, he stood by while someone else did, and that's unacceptable. That is improper, and I don't have the information about the other witness, but this is now a pattern. We also have, and we didn't include this in the motion because we don't have enough actual evidence in writing, but there are two other witnesses who were going to testify that refused to testify either because of
Judge, this is not part of the motion.
I'm sorry, guys, one at a time.
To get to this.
I'm going to sustain the objection. Is this part of your motion? I mean, there is a pattern, and I will say that the amount of times that the defense has filed a motion alleging prosecutorial misconduct is more than I have ever seen in any other case. At least 5 or more times you all have filed those types of motions.
Judge, we file motions we feel are appropriate and we feel the circumstances warrant.
All right, your motion is denied. What is left?
Judge, the only thing that's left is the state's motion in limine that I filed. It's SF-227. It basically pivots off the motion that Your Honor just denied to preclude disparaging comments directing at opposing counsel. And I filed it because I suspected that this issue coming up about Mr. Marcus trying to suggest that a witness not testify or change the testimony would be mentioned in closing argument, and that's entirely improper. And I would say into my motion, disparaging comments attacking counsel personally are strictly prohibited, and that's Frankie v. State at 59 Southern 2nd, 82, citing Brooks, 762 Southern 2nd, 879. As the court has heard multiple times now, it's entirely appropriate for a lawyer to talk to a witness before their testimony. That's what took place. The defense has no right to get up before this jury and say that anything was improper was done by anyone at this table.
Before I even get to this, I want to say one thing. Throughout this trial, I have made rulings which have not been respected, and things that I have said are not to be asked have been asked anyway. I want to say that after today, if I rule that certain things are not allowed to be mentioned, or if I have previously ruled they're not allowed to be mentioned, and they are mentioned, and this is fair warning, I am going to reprimand either side if you do this in front of the jury. I'm going to say, Ms. Bailey, I have told you not to say that, and I'm going to tell you again, the jury is to disregard that statement. And that is fair warning. I'm using my lovely court reporter as an example because I don't want to be accused of picking on either side. But if either side gets into something that I have said is not admissible, that's exactly what I'm going to do. So I'm going to assume it's a strategy of yours and you do not care whether or not you get reprimanded in front of the jury. I'm going to assume that's some type of strategy that you have specifically chosen, and if you are going to do that, I would ask that you please think about that, and if it's the defense that's going to do it, please speak to Mr. Cruz before you do that so that he is on board with any strategy decisions that you may or may not make. Is there anything else about this motion?
No, Judge.
Defense, do you want to respond?
Yes, Judge. The defense is fully aware of the instruction and that the court would give to the jury, and that lawyers are in fact permitted to speak with witnesses.
Okay.
What Jack Vasey testified to, which is in evidence, which 20 members of the jury heard, was how that call made him feel. And he testified under oath that Mr. Marcus was on that call. And the impression and the feeling that he got made him very uncomfortable. He also testified that he felt like they didn't want him to testify. That is not disparaging on anyone. That is exactly what this gentleman testified to, and that is what is in evidence, and the jury can draw any conclusion that they want to from his testimony, just like they can draw any conclusion from any other witness about their testimony. This is already in evidence, and this is the impressions that this gentleman felt as a result of a phone call that he received, and under oath he testified as to who was on that phone call. So that's the only thing that we may get into. I'm not going to point a finger at anybody. I'm not going to say that anything was improper. I'm just going to say, how did that call make Jack Vasey feel? And that's exactly what he testified.
You can argue any facts and evidence, but don't summarize them and don't ad-lib, because the arguments that I'm hearing from your side is summary and ad-lib and your impressions. If you want to argue facts and evidence, you make sure it comes directly from the transcript, because if it's not accurate, you can't say it.
That's fair, Judge. I'll read it from the transcript.
Judge, may I just make one request?
You may.
If that argument is made or statement is made regarding how it made him feel, I would just ask that the court read the instruction that at that time that lawyers are allowed to speak to.
That's part of the standard instruction. I intend on reading it. I intend to read it. I'm not going to read it at that exact moment. But again, make sure the exact argument comes from the record and nothing more.
No.
All right. Is there, other than I would like one lawyer from both sides to please go with Ian do we have any exhibit that we can use so he can? Can we have a thumb drive and you said there's a DVD also? State, did you say there's a CD or a DVD?
Yeah, there are some, I don't remember.
Okay, well let's try to take one of each item and have one. We'll do this tomorrow. My boss says we can't do it today. Is that okay with you all? We're going to have plenty of time tomorrow.
You're on, what time tomorrow?
I told the jury 8:30. I'd like to start right at 9 o'clock with closing arguments.
Thank you.
So, Your Honor, I have a question. If Mr. Sachs concludes his deposition at 11, his closing arguments, do you want me to go right into mine?
Please.
And I'm going to request maybe 15 or 20 minutes between our arguments so that I can text some stuff.
That's fine. Also, I can ask you all in the morning, in the abundance of question, how much time you want and whether or not you want a warning, and if you want to knock, if you want me to just say 15 minutes.
Judge, I'm not going to need a warning. I won't need that, and I can't tell you specifically exactly how long it'll be.
Okay, well, then the state can tell me how much time they need, and then that's how much time I'll give you. I mean, I need to know, I don't need to know exactly, but I need to know about how much time.
Well, I'm going to ballpark it around 2.5 hours, but I just want you to know I can't.
Okay, that's fine, that's fine. So 2.5 hours.
Because I'm still in the process.
No, that's fine. So both sides get 2.5 hours.
And then at the conclusion of closing arguments, we'll review the revised jury instructions.
Yes. And depending on how long Mr. Sachs takes, if he does take 2.5 hours, then maybe we'll break for a short lunch before. Just depending on if he's shorter, if he finishes early, we'll just play it by ear. I don't want to take lunch at like 10:30, but.
Okay.
Okay.
Thank you.
Okay, so some decisions were made. It sounds like the judge is going to allot about 2.5 hours for each side, that she will ask them tomorrow morning, how much time do you want to be given? The defense, Craig, said, well, it's kind of hard to estimate, but maybe 2.5 hours.
Yeah, that's what you said, in the ballpark of 2.5 hours.
So these are going to be the closing arguments.
Yeah.
And, as an attorney, you have probably been preparing, but how much are you changing and modifying your closing argument up until the very end?
It's usually a personal thing. I always did it all the way up until the very, very end, even incorporating what the state says and bringing it into. But as a general outline, everything that you've presented up to this point in trial is presented with the idea of what you're going to argue in closing argument. So in order to craft it well, you have the narrative of your closing argument in mind as you're preparing the witnesses and presenting the evidence that you know you're going to argue finally to the jury. So a lot of the things that may have happened that you say, like, gee, that witness didn't really make sense. Why did they put that person on? I don't know why they asked that particular question. Some of those answers will get some of those questions will get answered in the closing argument.
The state goes first, correct?
Correct.
And the defense gets the last word.
Right.
So we believe that probably we'll hear from the state right at 9 a.m. That's when the judge wants for the jurors to be ready to go. Well, she wants them to be ready to go at 8:30 so that they can begin at 9, and then probably a lunch break, and then the defense will make their case.
Right. That would probably be the easiest way to do it. Let the state present their closing argument, break for lunch, because defense counsel said she needed a few minutes to make sure all the technology works for her, because I'm assuming she's going to be showing some of the documents and so forth to the jury. At break for lunch, she can accomplish that, come back from lunch, have the defense closing, and then go into the jury instructions.
So really anything that's already been entered into evidence can be brought back.
Absolutely.
Remember the time that the defendant said this? Do you remember the video of him doing this?
Right. I wouldn't be surprised if at some point the state in their closing argument is going to pick up that gun and walk it close to the jury. That's what I would do.
So the next thing that they do is then give the detailed instructions to the jury, and that was what part of this hearing was about, right? To lay out how they're going to tell them what they should do. And this is a pretty monumental task for these jurors. I mean, 17 victims, different aggravating factors, mitigating circumstances. This isn't guilt or innocence. This is a little different.
Right. This is a huge task for the jury. And I mentioned a couple of times before that, in all this stuff, we got to keep in mind the attention that the jury's paying to this, the work that they're putting in on this, all the things that they're seeing, and all what they're about to do. They've done a lot of great work up to this point, but the real work starts tomorrow and throughout the deliberations. That's where it's going to get really personal and intense, and nobody knows what goes on in a jury room when they're deliberating, and that's the way it's supposed to be. We're not supposed to know. We don't get to know. We just get to know what their decision is, and that's the way it's supposed to be.
What we don't know yet, at least I don't think we do, is will the jury be charged tomorrow? We think probably Wednesday if the jury instructions are a lengthy thing, right?
Yeah, it was unclear. The judge didn't really say. Maybe they can get them done tomorrow because I think of the verdict forms that they're going to read, 14 of them are exactly the same. So she's just going to read one and incorporate all 14 of those names, and then the rest of them they are going to be read. So I think that makes 4 total verdict forms read, which would shorten the jury instruction quite significantly.
The other 3 are, just to clarify, right, those are the teachers.
Correct.
Those are the adults.
Right.
And so there's an additional aggravating factor under the Florida statute that I think would be added, and that was one thing that they talked about today. But it was one of the aggravators.
The elected or appointed public official aggravator.
Exactly.
Right.
And there were some questions over, well, if you're hired as a teacher or a principal, are you an appointed public official?
Right.
Right.
Yeah, and the defense had asked that the word elected be elected or appointed, keep the word elected in, and the judge didn't want to the state didn't want the word elected. The judge granted that, so they're not going to hear the word elected. They're just going to say up here, appointed public official. And the jury's going to have to decide whether the evidence established that particular aggravator or not. Whether these individuals were appointed public officials.
I think so many people have been waiting for this moment to happen tomorrow, where we're going to hear the closing arguments from each side. They'll have that final chance to make their case. The jurors, do they pack a bag tonight?
I don't know.
Yeah.
If they're probably, to be on the safe side, they might, because if they get charged tomorrow and the jury instructions are finished tomorrow, they're supposed to go right into deliberation. So they might need to pack a bag for tonight.
Because they will be sequestered. They will be in a hotel.
Correct.
Some of their engagements are certainly limited. Phones, obviously, they haven't been able to talk to anybody about this case since the beginning, since July.
Right. Yeah.
July.
That's a big task to ask the jury to do that, and hopefully they've followed that instruction and are doing. I have no reason to believe that they're not doing their job properly. They always seem to be really well oriented in the entire process, and Christina would say that they seem to be during the case. So there's no reason to believe that they're not going to be meticulously following the court's instructions.
Taking notes, engaged. That's been the word from Christina Vasquez, who's in the courtroom. This is going to be a big day tomorrow. Of course, we're going to be there every step of the way. Court is starting at 9 o'clock. That's the plan for closing arguments. We'll see you tomorrow.
Has influenced other girls to follow their dreams. Well, as an only child of a football coach, and I probably should have been named Christopher, not Christy. This is certainly a story I can get behind. Good for her. Way to go, Ava. I would have loved to have done that.
Yeah, your dad probably just settled with Christy.
He was okay with it eventually.
Okay.
I did okay.
We'll see you later.
We'll see you later.
All right. Right now on Local 10 News at 5 o'clock, this South Florida teacher has been arrested and charged with sexually assaulting a teen, and we are now learning how authorities found out.
And Local 10 is live at the White House with reaction after Russia delivered a series of sudden strikes overnight in Ukraine.
The jury will soon begin deliberating if the Parkland shooter pays for the MSD massacre with his own life.
And a major mess after a driver loses control and crashes all the way into a home in Coral Springs.
Plus, only Local 10 is investigating after a politician is accused of trying to score votes with free groceries.
Local 10 News starts right now.
And off the top at 5 today, breaking news. A Fort Lauderdale teacher has been arrested for allegedly having sex with a teenager he met online.
That man, we're learning, is a science teacher who has gotten national recognition. Christy is in the newsroom with the breaking details.
And that victim, who is from Connecticut, actually wrote a college entry essay about this situation, about this sexual assault, but that's when the school counselor read it and called police. It's alleged that Carlos Montero met that victim in April of 2021 and had sex with the boy knowing he was younger than 18 years old. The two had talked on Tinder, and then he went to visit a family member in Golden Beach. The young man did. He snuck out one night to allegedly meet Montero in Fort Lauderdale, and that's where the assault allegedly happened. The victim says that he did not realize it was even wrong until he went back home and told his friends what had happened. Montero surrendered himself at the Broward State Attorney's Office and is now facing several charges, including sexual battery on a minor. And again, we have learned Montero received a presidential award for excellence in mathematics and science teaching. That happened back in 2015.
You're seriously laughing right now? We are dealing with a 15-year-old. Unfortunately, that's part of the reason why I want Christy to have more of a snapshot of him, because he is very immature. All right, October 31st. Take him out, please. I can't have him in here. Take him out.
Two teens charged after a chase that ended in a crash that killed an innocent woman faced a judge today, and one of them was kicked out of the courtroom for his behavior. Local 10's Ian Margol is live with more on the judge's outraged reaction. Ian.
So the 15-year-old appeared around 9:30 this morning, and the younger boy appeared this afternoon, but one of them had to be kicked out of the courtroom. The judge fed up with how he was acting.
October 31st. Take him out, please. I can't have him in here. Take him out.
Judge Stacey Ross kicking a 15-year-old defendant out of her courtroom Monday after he began laughing while the judge and his attorney discussed a behavioral assessment that will help determine whether or not he'll be tried as an adult.
I want to make sure that she is able to provide us with a very thorough assessment so that the state has that thorough assessment to make their decision. You're seriously laughing right now? Jacoby.
Jacoby Besant was one of two teens arrested in August for allegedly breaking into a Fort Lauderdale home and stealing a Mercedes before leading police on a chase that ended with a deadly crash. Besant was allegedly behind the wheel, while then 13-year-old Ja'Cory Flournoy was in the passenger seat.
And I understand the process takes time, but I'm happy as long as it's still behind bars.
Emily Farias' sister, Maria Tellez Valderrabano, was killed in the crash, leaving behind several children and a tight-knit family. Besant and Flournoy are now facing serious charges, and the state is working on determining if they will be tried as adults.
I have not grieved my sister yet, and I will not grieve for until I get justice.
So both boys are going to continue being held in custody in a juvenile detention center for now. They have hearings scheduled for later this month. Flournoy, who was only 13 when this all happened, likely will not be charged as an adult, but Besant, who is 15, very well could be, and he could face serious prison time. Live in Fort Lauderdale, I'm Ian Margol, Local 10 News.
Ian, thank you. We are following a developing story in northeast Miami-Dade where one person has died after 4 were shot outside of a home. Police say it happened last night just after 7 p.m. A woman and 3 men were shot in the drive-by attack. So far, police have not made any arrests.
Well, the jury will soon decide if the Parkland killer pays for the MSD massacre with his own life.
Closing arguments in the penalty phase are expected to begin tomorrow. Local 10's Christina Vasquez is live at the courthouse with more on what's next. Christina.
But first, some very important work was underway today. So the jurors not in the courthouse today as attorneys for both sides and the judge went, and you will see in some cases even word for word down to the language, even things like if they're italicized on jury instructions. The reason why those are critical. Jury instructions are essentially a roadmap to the law, a way to guide the jurors through deliberations. And so you're about to hear how both sides, that linguistically the words, they matter because they're trying to dovetail the case law and be clear in the instructions, but also to their unique trial strategies.
I don't think it's a surprise to anyone to know that this is my first death penalty case, and I am looking at these instructions thinking not extremely clear.
They went paragraph.
Judge, we do have an objection to number 7.
By paragraph, word.
Anywhere that it states evidence, we would object to that word and would request to use testimony.
By word.
So we're going to take out the underline.
To find agreement on jury instructions. Each side advocating for inferences that bring clarity to the issues they want jurors to consider during deliberations.
It's not for a school shooting where a teacher is murdered. That's our position. They are not appointed or elected.
They want to leave in the word elected official for this jury instruction, when clearly we know that these adults who were murdered by the defendant were not elected.
The process laborious but critical, as the instruction language they are working through today will guide jurors through deliberations.
They're going to have to be focused in weighing what's been presented to them, again, individually though, 17 times. They've got to come up with 17 different verdicts here.
And that is such an important point there by legal analyst David Weinstein. Again, this is a 17-count capital case, so there are 17 verdict forms. There's 1 count for every 1 victim in this case. And so these jurors will have to go count by count. They're going to be weighing the evidence from the state and the defense, and they do have to be unanimous on that count of deciding that death is the appropriate punishment, and they'll go through that 17 times. Also, and listening to some of the arguments that both sides made just as they went through in quite amazing detail, very granular into the language of jury instructions, you really got to hear, I think, a little bit of what we can expect during closing arguments tomorrow. So we'll have more on that coming up at Local 10 News at 6. For now, back to you.
So, Christina, to be crystal clear, to play off of what you and David just talked about, unanimous, 17 different verdicts, or could it be 15 out of 17 death versus life, or does it have to be 17 verdicts that say for death for Nikolas Cruz?
I'm glad you asked the question. It's such an important nuance. So, and the question though, I'm going to parse it out and unpack it because it's that important. So 2 different concepts here. One is you have 1 count for each person, 17 counts. So count by count, that's what we're talking about, where they have to be unanimous in deciding if death is the appropriate punishment. So let's just take, let's say, murder victim Peter Wing. So if they're getting to Peter Wing's count, if all 12 are unanimous saying, we think for this count that death is the appropriate punishment, then it's death. If just one says life, it's life. So how does that then play out to that second equation, which is now you're looking at the totality, 17. So let's say, and let's stick with Peter Wing actually for this analogy or example as we kind of run through this concept. So we have these 17 counts. Let's say 16 of those counts The juror in this case decided that life was the appropriate punishment. But on Peter Wang's count, they decided that death is the appropriate punishment. Then he is facing a jury recommendation for death to the count of Peter Wang. So that would mean that the jury in this case decided that death is the appropriate punishment for Peter Wang's count. Let's say, again, using this as a hypothesis, one of 17 murder counts, the only one where the jury was unanimous in deciding death is the appropriate punishment. So that's how that will play out. And it's important because you're going to hear it play out that way tomorrow. So hopefully a little on-ramp or pathway so that you can make sense of it.
Okay, our Christina Vasquez covering it from the very beginning. Thank you, Christina. And stay with Local 10 for complete coverage of this trial. You can also find the latest updates on local10.com, our social media pages, and the Local 10 Plus app on your smart TV.
New outrage today from around the world, including the White House, after the Kremlin claimed responsibility for sudden strikes across Ukraine that killed several and injured dozens more.
Russian President Vladimir Putin says those strikes were retaliation for what he calls a terrorist attack, the bombing of a bridge to Crimea that was the Russian army's main resupply pipeline.
And we are now getting reaction to those deadly strikes from the Biden administration. Our D.C. bureau chief Ben Kennedy is live at the White House now with much more. Ben.
Calvin, Nicole, President Biden condemned the attacks and then joined world leaders telling Russia to stand down its troops. Firefighters scrambled to put out flames after Russian missile strikes hit the capital city, Kyiv, Monday, knocking out critical infrastructure, damaging cars and homes in what Ukrainian leaders are calling a terror attack on civilian targets. That left at least 11 dead and more than 60 injured. Russian President Vladimir Putin confirmed today's strikes are in response to what he calls a terrorist attack over the weekend, the bombing of a key bridge in Crimea, which damaged a critical supply route for the Kremlin's forces. President Biden returned to the White House Monday afternoon, releasing a statement saying his administration strongly condemns Russia's missile strikes, adding that these attacks only further reinforce our commitment to stand with the people of Ukraine. His remarks come less than a week after issuing a strong warning that the risk of nuclear Armageddon is at its highest level since the 1962 Cuban Missile Crisis. And tomorrow, the G7 will hold a video conference. It is there Ukraine's President Zelensky will talk, telling the U.S. and its allies what they need to continuing deterring Russian aggression. Reporting live at the White House, Ben Kennedy, Local 10 News.
Look now at the closing numbers on Wall Street. Ben, thanks a lot. Let's take a look here. The Dow is down 93 points, closing out at 29,202. Time now to talk tropics and Central America, getting soaked by Julia.
Chief Certified Meteorologist Betty Davis is here with your tropical update. Good afternoon. Well, Julia, the circulation center has unraveled this afternoon right in the vicinity of Guatemala. So at this point, it is mere remnants, but still drenching these parts. What's interesting is those remnants, once they get offshore of Mexico on the Pacific side, they may evolve into a new tropical cyclone. So that is something we'll be watching for in the days to come. Good news is we won't have to worry about this here in the U.S. or South Florida. Notice that development potential at 30% over the next 5 days. Another area, by the way, being highlighted by the National Hurricane Center has to do with a disturbance over the Yucatan Peninsula. That expected to head over toward the southwestern Gulf of Mexico. 20% development potential over the next 5. So that is low. Not too concerned about that feature at this point. It appears that the upper level winds are going to become more unfavorable in the Gulf as we're moving through the week. But those are the only 2 items. Also tracking a cold front. You'll want to hear more about that coming up. Calvin?
Betty, thanks a lot. Only on 10 today. The stakes are high in the midterm elections.
But one local politician is accused of some shady behavior. We are hearing of long lines of voters waiting for hours to get grocery gift cards. But where is the money for all that free food coming from? You don't want to miss our one and only exclusive investigation, all new at 5:30.
But first, police here in Florida making a big bust during a traffic stop. And wait until you hear how much they seized. When Local 10 News, we'll be right back.
Be an authority on weather with the new Local 10 Weather Authority app. Live interactive radar, live streaming forecasts, futurecast, lightning tracker, and more. Activate weather alerts and select weather from unlimited locations. Drop pins of weather-related photos or video. The power to know weather conditions anywhere. And it's completely free. Download or update the Local 10 Weather Authority app now. Search WPLG in the App Store. Like us, LOL. You're going to love us. Follow Local 10 News on Facebook. You'll get the hottest videos going viral, the top stories making headlines, up-to-the-minute weather updates, and breaking news as it's happening. So go to Facebook, click like on Local 10 News, and show your love.
Police tweeting out this picture of a big drug bust. Bicycle officers stopped a car on Church Street and a police dog sniffed out all of these cannabis products. Cops seized more than 17 pounds of marijuana, 25 pounds of edibles and THC products, a quarter of a pound of mushrooms, ecstasy pills, a loaded gun, and more than $5,000 in cash. The driver was arrested and is now charged.
We are following a developing story in California where jury selection is getting underway in the second sex crime trial of Harvey Weinstein.
He has already been convicted of similar crimes in New York. Let's go to Christy now in the newsroom with more on this one. Christy.
The 70-year-old Weinstein is already serving a 23-year sentence for rape and sexual assault in New York, but now in California, the first of 75 prospective jurors are being questioned in his latest trial. Weinstein is charged with 4 counts of rape and 7 sexual assaults involving 5 women in L.A. The alleged assaults happened between the years 2004 and 2013. The women will be testifying anonymously to protect their identities. The trial expected to take 8 weeks. Now, if he is convicted in California, Weinstein will face a life sentence there, regardless of the outcome of his New York appeal. Jury selection is expected to take about 2 weeks, with opening arguments scheduled for October 24th. Cameras will not be allowed in the courtroom. And then we have some other news coming out of LA as well. The city council president has resigned after public outrage over racist comments about another council member's son she made last year during a redistricting meeting.
The kid is bouncing off the effing walls on the floor, practically tipping it over. There's nothing you can do to control him. I was like, this kid needs a beat down. Like, let me take him around the corner and then I'll bring him back.
Well, in a recording, Nuri Martinez also refers to the council member's 3-year-old son, who is black, as a little monkey. She says that in Spanish. Now, after announcing her resignation, Martinez released a statement saying she takes responsibilities for her actions and there are no excuses for what she said.
All right, Christy, thanks a lot. Live look right now, Mount Sinai Medical Center Tower Cam. Beautiful day to begin our week after a rainy weekend, Nicole.
Yes, it was. So it's nice to see it a little bit drier today, Betty.
We are just 5 days away from the fixed calendar end date to the rainy season. So we'll see if the weather is going to actually line up with that fixed calendar end date. Right now, I'll go ahead and let you know, it looks as though that is going to be the case. Outside right now, 88 degrees in Miami. Feels humid. Winds are from the southeast at 9 miles per hour. I should mention that though we're nice and dry out, you may notice some standing water out there around the time of high tide. Minor saltwater flooding, those vulnerable spots along the coast of Broward and Dade, up around Palm Beach County as well. The Keys too, we'll have to watch out there between 9:30 and 11 when that next high tide comes in. We know the deal with the king tides around here. Here's the Doppler radar, though. Hardly a drop of rain to be found over Broward, Dade. We had a few showers going on either side of the Keys. It looks as though those are even starting to dry up. Just a few things to look at down around the straits and way offshore. A couple showers and storms developing off Andros Island. So it could take some time for any of that to drift in our direction. So if you are stepping out for the evening, rain should not be an issue. Between now and 7 p.m., we'll say partly cloudy. We'll say scattered clouds, not scattered showers at 9. That should be scattered clouds as temperatures drop off into the low 80s, and then it's upper 70s for the overnight hours. Now, overnight, we're not going to rule out a spotty shower, as with the easterly component to the winds, we may get something floating in or moving in our direction off the Atlantic waters. But what we do see is a front stalled right across the central part of the state. And of course, you know what side of the front we're on. We're on the warm, humid side, while Jacksonville to Pennsylvania Pensacola, they're on the side of the front where the air mass is a lot more comfortable. We're talking dew points sitting in the 60s, 66 in Jacksonville, 50 in Tallahassee, and how about that 43 in Pensacola? So that measure of moisture is way down there. So how does it feel? Well, you can call up your relative up there and ask. I bet they would say something like pleasant or wonderful. And if you ask me how it feels outside right now, I'd say it's sticky with our dew points running in the low and mid 70s. And we've got more of that type of stickiness to come for Tuesday. It's going to be warm, sun cloud mix, similar to today. We won't rule out a few spotty showers. Wednesday, same deal. We don't quite get into the comfortable air up to the north. Spotty shower potential, warm weather. It's going to take a cold front to really get us out of the situation we're in. And we do foresee a cold front marching across the Midwest, closing in on the Northeast on Thursday, the tail end of that front on Thursday, starting to close in on the Southeast. And once that sweeps South Florida, and I do have that in the forecast plan, it means a refreshing change for us. We'll start to break into northeast winds for the weekend, and it sets us up nicely. So here we are tomorrow, showing a high temperature forecast of 89, rain chance at 30% on Wednesday, 30% on Tuesday, 40% on Wednesday, highest on Thursday, and then look at how low that rain chance goes for the weekend. That is a sign of the drier air coming in here on the northerly winds. So less humid weather, feeling a little cooler at night. Oh, I can hardly wait. Nicole.
Me too. Sounds good. Thank you, Betty. Well, some people, they just have no shame.
And like this woman here who was caught on camera stealing somebody else's deliveries in broad daylight. And wait until you hear what was in those boxes, all new at 6.
Authorities are closely monitoring one of Europe's most active volcanoes after it erupted over the weekend, threatening thousands.
Plus, we are now seeing the body camera video of a police shooting in Texas that cost one cop his badge. Clay.
I'm Clay Ferrero. Quarterback questions for the Miami Dolphins. We'll bring you an update on Teddy Bridgewater today and what players are saying about the new rule that knocked him out of yesterday's game. That's next in sports.
Local 10 News on Facebook. You'll get the hottest videos going viral, the top stories making headlines, up-to-the-minute weather updates, and breaking news as it's happening. So go to Facebook, click like on Local 10 News, and show your love. Never miss a beat with Local 10 Plus.
And it's right here in our own backyard.
A one-stop shop for all your news.
North Rock Island Road has since reopened.
From traffic updates and weather alerts to cooking, home projects, health, and politics.
From the 26th Congressional District.
We've got you covered anytime, anywhere. Local 10 is right there with you on the scene of breaking news, in the stands at sporting events, and exploring SoFlo's hidden gems. Stream at home or on the go, 24 hours a day. Only on Local 10 Plus.
Welcome back. The Miami Dolphins are hoping to bounce back from a tough loss to the New York Jets.
And the Dolphins have questions of a quarterback after concussion concerns sidelined two starters. Let's get right over to Local 10's Clay Ferrero live in Miami Gardens for us. Clay.
Calvin and Nicole, the NFL put a new concussion rule into place to try to protect players after what happened to Tua Tagovailoa in that game against the Buffalo Bills a couple of weeks ago. Little did they know that they would get impacted by that new rule so quickly. Yesterday, Teddy Bridgewater starting the game in place of Tua Tagovailoa. He would get hit on the very first play of the game and go down. Now, video has not shown us any example, any evidence of him stumbling after getting up. However, a spotter up in the booth said that he or she saw Teddy stumble, and because of a new rule put into place because of what happened to Tua, that meant that Teddy was out of the game and could not return despite the fact that he passed all concussion tests. That meant that Skylar Thompson had to come into the game for the Miami Dolphins, and look, he did about what you would expect for a 7th-round pick as a rookie. Did some good things, some not so good things. Ultimately, it was not enough for the Dolphins to beat the Jets in New York yesterday. And now the Dolphins are left with questions about who's going to play quarterback in this upcoming game. We've been listening to players today, and Alec Ingold told us that, look, we understand players want to get out there and play, but we're also happy that there are people looking out for our well-being, like our teammate Teddy Bridgewater.
I mean, that's not my job. I mean, that's the first thing you could say. But no, I think we were all really bummed at how Teddy went out that first play. Obviously, somebody saw something, and we're all competitors. We're all going to try and strap up. We're all going to try and play. That's just the nature of the beast. And there are people out there looking for us, and a lot of hindsight from ex-players, people in those positions. So as much as it hurts in the short term, there's people looking out and just being extra cautious and safe. So definitely double-edged sword, but it was really tough to see Teddy go out like that, and just knowing how he prepared, and it was his moment, right? So we're really fighting for him.
And players have told us that Teddy Bridgewater is in the building today. He is feeling fine, doing well. We're still waiting to hear from Dolphins head coach Mike McDaniel. We were supposed to hear from him an hour ago. We're going to run back inside, and hopefully we hear from him and get an update on the quarterback situation moving forward. For now, we are live at Dolphins headquarters in Miami Gardens. Clay Ferrero, Local 10
Yeah, I
News.
guess the big question is who's going to be taking the snaps when they suit up this upcoming weekend, huh, Clay?
Sources tell me it's going to be Nicole Perez.
Oh,
actually,
like
that's
that.
the rumor out here. I don't know if maybe you'd like to confirm or deny that.
You just might not see me at work the next couple of weeks after
She may be a little sore.
recovering.
Okay. Clay, thanks a lot. Next at 5:30 now, driver losing control and slamming through a home in Broward. Find out if everyone made it out okay.
So much of Southwest Florida is in shambles after Hurricane Ian. We'll show you how election authorities are working to protect the integrity of the midterms.
Plus, promise made, promise kept. See how the emergency supplies collected in Miami Gardens last week for underserved storm survivors along the Gulf Coast are being delivered when Local 10 News at 5:30 starts in just a few minutes.
Like us. LOL. You're going to love us. Follow Local 10 News on Facebook. You'll get the hottest videos going viral, the top stories making headlines, up-to-the-minute weather updates, and breaking news as it's happening. So go to Facebook, click like on Local 10 News, and show your love. Never miss a beat with Local 10 Plus.
And it's right here in our own backyard.
A one-stop shop for all your news.
North Rock Island Road has since reopened.
From traffic updates and weather alerts to cooking, home projects, health, and politics.
From the 26th Congressional District.
We've got you. Starts right now.
Crazy video of a driver going on a crash course, barreling all the way inside a home in Coral Springs. Incredibly, no one got hurt in that crash.
But is the house still safe to live in? Local 10's Sinella Sabovic live on the scene of this developing story. Sinella.
Well, Louie and Christy, according to the homeowner, it was her neighbor. He was accidentally trying to get out of the driveway here when he somehow plowed into the front of the home here. You can see it has all since been boarded up, and it is, yes, has been deemed unsafe and unlivable.
Well, I woke up this morning for a loud crash.
Michelle Rodriguez woke up to find a car in her living room.
There was smoke everywhere from the car, the dust from the just from the debris, and trying to figure out what happened.
Her living room is in shambles with debris scattered everywhere. She says as her neighbor from across the street was leaving his driveway, he accidentally plowed right into the front of her home.
I'm like, "Are you okay?" And he was obviously very shooken up, and he was upset and trying to let him know it's okay, I'm fine.
It's unclear if the neighbor confused the gas and brake pedals, but Rodriguez is thankful he's okay.
And we're good with our neighbors, known them for years. We've been here for over 20 years. They're good people, and of course, I hope they're okay and it'll be taken care of. You know, I'm just glad no one was hurt.
The family is now cleaning and boarding up as they wait for an insurance adjuster to assess the damage.
And they tell us the insurance adjusters are currently on the West Coast dealing with the aftermath of the hurricane. But again, the family cannot live here. It has been deemed unsafe. Again, unlivable. We did reach out to the neighbor. He was not home for a comment, but neighbors here tell me that he did get checked out and he is okay. So that is the good news in all of this. For now, that's the very latest here out of Coral Springs. Sinella Sabovic, Local 10 News.
All right, Sinella, thank you. That is some good news there. 4 families have to find a new place to stay after their quadruplex caught fire. That's in Northwest Miami-Dade early today. It happened at Northwest 2nd Avenue, right at 156th Street, about 4 o'clock in the morning. One resident telling us he woke up to the smell of smoke and immediately ran outside.
I was sleeping and I heard somebody call fire, but in Creole, like Tife, and I smelled something funky, and I get up, I grabbed my phone and I went outside, but the only thing I was able to get was only this gin, that's all.
Well, it did take 15 fire crews to get that thing under control and keep it from spreading to neighboring homes. No injuries reported, no word on the cause yet either, but the Red Cross is helping these 4 affected families.
Only on Local 10 long lines in North Miami Beach, some voters waiting for hours to get a Publix gift card.
And now there are questions about whether that event was actually legal or just a ploy to get votes in the upcoming election.
Local 10's Glenna Milberg is live with our one and only exclusive. Glenna.
So this is not so much what was done, but how it was done. And we're talking about a lot of public money, money that belongs to the citizens of North Miami Beach, being used by commissioners in a pretty questionable way.
The last day of the gift card giveaway.
3 mornings, miles of cars, some in line literally overnight.
1 to 3 o'clock in the morning.
This was a grocery gift card giveaway the city of North Miami Beach to its residents.
Good morning, good morning.
Billed by this commissioner, Paulie Villard, as public service.
It's not taxpayer money.
It is most certainly public money, but now under scrutiny as her campaign stunt.
We're going to spend $225,000. We're not going to have a discussion on that.
The giveaway passed with little discussion August 16th. The city would buy 1,500 $150 Publix gift cards with money from the city's federal COVID relief allocation. This resolution directed the city manager to allocate them to those who could prove they live in North Miami Beach and prove financial hardship, and do it within 45 days of that meeting. But they missed that deadline. Instead, the giveaways late last week were planned just as mail-in ballots were arriving to city voters. There is no video of the checks for proof of residency or financial hardship, for an accounting of who received gift cards and how many, or proof that all were given away.
We will put you back. Thank you so much.
Can I give you my phone number?
Neither the commissioner nor the city manager returned calls today.
Please try your call again later.
When they learned what we were asking about.
We are still holding out hope to hear from the city manager who was put in charge of the logistics of the giveaway, or the commissioner who seemed to take ownership of it all. We do know that this has been reported to the county's Commission on Ethics. I'm Glenna Milberg, live in North Miami Beach today, Local 10 News.
Interesting timing indeed. Okay, thank you, Glenna. An arrest has been made in a deadly shooting in Southwest Miami-Dade over the weekend. 27-year-old Rayan Aviles is charged with 2 counts of second-degree murder with a weapon. The shooting happened Saturday night on Southwest 299th Street. That's where 2 men were found shot to death. And we're working a couple of crime alerts right now for you. The first one out of Lauderhill. That's where 2 men were rushed to the hospital after a shootout last night. This happened near 441. Both men having non-life-threatening injuries. But if you know something about this incident, you're urged to call BSO. And this man was arrested in connection with a double shooting that happened in Tamarack. Basil Nelson faces several charges, including attempted murder for that. Deputies found both victims shot Saturday night on Hampton Hills Boulevard. They also were rushed to the hospital, but their conditions remain at this point unknown to us.
Candidate for Governor Charlie Cruz out helping hand out storm relief supplies in Fort Myers today as he continues to campaign to unseat Governor Ron DeSantis. And now there are questions about how the devastation caused by Hurricane Ian could impact voting in Southwest Florida. Local 10's Hatzel Vela is live with what he's learned. Hatzel.
So, Louis, you know Lee County was one of the hardest hit by the storm, which makes sense why this would be one of the places where elections going to be a challenge. But tonight, the election supervisor is telling us that he is asking the governor to step in. In the Fort Myers, Dunbar community, a food giveaway for those affected by Hurricane Ian. There we find David Ruffin, who's running for mayor.
My main concern is the people
Will they have transportation for the people?
Certainly not the only one concerned about turnout and voting in Lee County, which could play a crucial role in the general election, given that it's a heavily Republican county. As of today, Lee County has more than 226,000 registered Republicans, close to 129,000 Democrats, and more than 162,000 independents. That's more than 500,000 registered voters.
Southwest Florida's been through a traumatic experience, and every opportunity to make it a little bit easier to cast that ballot by November the 8th, we need to do.
Charlie Cruz, the Democratic candidate for governor, thinks early voting should be expanded. On Friday, Cruz's opponent and current governor Ron DeSantis talked about the upcoming election in areas devastated by Ian.
I want to keep it as normal as humanly possible.
We went to the office of the election supervisor here in Lee County. Tommy Doyle tells us they've been assessing their needs.
We probably have 50% of our polling places are available, but we don't have the staff to even man 50%.
So he's petitioning the governor, asking for an executive order that would open voting centers starting October 24th through Election Day, basically an extended early voting period. And the election supervisor is actually also urging folks to vote by mail. Even those who have been displaced, he says, can get a ballot. All they have to do is call his office. For now, reporting live from Fort Myers, I'm Hatzavala, Local 10 News.
Okay, Hassel, thank you. And by the way, the clock really is ticking if you want to register to vote in this upcoming election. If you haven't already done so, and plenty of people are working to make sure that every eligible voter is ready to go. Local 10's Leanne Morhone is live. She's going to continue our team election coverage now. Leanne.
And the Miami-Dade elections headquarters here in Doral is right behind me. It will be open extra hours tomorrow to help accommodate some of these last-minute registrations. If you want to know how to register so that you'll be able to vote for that November 8th election, listen up. The deadline to register to vote in time for the November midterm elections is Tuesday, October 11th. In Miami-Dade, you can register online by visiting IamElectionReady.org, in person at county libraries, the elections office from 8 a.m. to midnight, or the Stephen P. Clark Center in downtown Miami from 8 a.m. to 5 p.m. You can also submit your application by mail, but it must be postmarked October 11th. In Broward, you can register online at browardvotes.gov, in person at any DHSMV, Broward Library, or at the elections office in Fort Lauderdale from 8:30 a.m. to 5 p.m. Anything mailed in Broward must also be postmarked by Tuesday's date.
And I would encourage folks who do have the right to vote to go ahead and get registered.
Broward Election Supervisor Joe Scott also says he wants to clear up eligibility requirements for certain potential voters with criminal records.
For people who are convicted of a murder or a sex offense, you never get your right to vote restored. However, for anybody else who is convicted of a felony, your right to vote is automatically restored as soon as you have fully completed all of the terms of your sentence.
The Miami-Dade Supervisor of Elections, Christina White, said in a statement, quote, "If you want to vote in the upcoming general election, time is running out to register." She goes on to say, "I also encourage voters to check out their voter registration status online or by calling our office at 305-499-VOTE. So again, that deadline is tomorrow at midnight. The November election will be on the 8th. If you want more information, you can head to our website, local10.com. Live in Doral, Leanne Morejon, Local 10 News.
Important information. Thank you, Leanne. A South Florida teacher has been arrested and charged with sexual assault.
And we're now getting some really disturbing new details about exactly how police say this all went down. That's all new at 6.
We're now seeing body cam video of a police shooting that cost the officer his badge. We'll tell you how the teen who was shot was doing.
Plus, one of Europe's most active volcanoes just blew its top again. Find out why people are being told to stay inside, and it's not just because of all the lava.
But first, a live look outside all of our weather cameras here in South Florida. Each and every one of them picture perfect. Boy, what a difference a day makes. That weekend was soggy. I'll tell you what the rest of the week looks like. Betty Davis next with your forecast.
Like us, LOL. You're going to love us. Follow Local 10 News on Facebook. You'll get the hottest videos going viral, the top stories making headlines, up-to-the-minute weather updates, and breaking news as it's happening. So go to Facebook, click like on Local 10 News, and show your love. Never miss a beat with Local 10 Plus.
And it's right here in our own backyard.
A one-stop shop for all your news.
North Rock Island Road has since reopened.
From traffic updates and weather alerts to cooking, home projects, health, and politics.
From the 26th Congressional District.
We've got you covered anytime, anywhere. Local 10 is right there with you on the scene of breaking news, in the stands at sporting events, and exploring SoFlo's hidden gems. Stream at home or on the go, 24 hours a day. Only on Local 10 Plus.
One man killed, 7 others injured when a driver plowed right into a crowd. This is out of Colorado and Golden. It happened early Sunday morning after some sort of an argument between 2 different groups. The sheriff's office says 29-year-old Ruben Marquez was arrested and charged with first-degree murder as well as multiple assault charges.
And we're now seeing the body cam video from a police shooting in San Antonio, Texas that cost the officer his badge. And we have to warn you, this video is graphic. The officer had spotted a car he thought had fled from police the previous day. He opened the driver's door and ordered the startled 17-year-old to get out.
Get out of the car.
Shots fired! Shots fired! Shots fired!
After the teen shifted the car into forward, the officer fired 5 more times. 17-year-old Eric Cantu was found a block away, suffering from multiple gunshot wounds. He's in critical condition in the hospital. His passenger was not hurt. The San Antonio Police Department fired the officer who was on probationary status for violating department policies. The district attorney is investigating the shooting. Charges against the teen have been dismissed. In Italy, the Stromboli volcano erupted near Sicily Sunday. Residents were told to stay inside and stay away from doors and windows because the glass could break because of all that volcanic activity. Mount Stromboli is one of the most active volcanoes in the world.
And we're also seeing some widespread flooding. This is out of Central America after Hurricane Julia made landfall in Nicaragua as a Category 1 hurricane yesterday morning. This is what it looks like right now in La Lima, Honduras. Now, Julia was packing winds of about 85 miles an hour when it hit. It brought nearly a foot of rain to some areas. The storm surged more than 6 feet along the coast of Nicaragua. 3 deaths are already being reported in Honduras, where there are more than 9,000 people in shelters. And take a look at the devastating flooding that's hit Panama after Julia as well. You can see the steep banks where this river was raging more than 20 feet above flood stage during the storm. Storm survivors could also be seen collecting mattresses and other supplies for temporary storm shelters. And there is at least 1 death being reported there in Panama and more than 250 evacuations. 8 deaths are being blamed on that storm in El Salvador.
All right, take a live look from our Mount Sinai Medical Center tower cam, where it is beautiful. Finally, the sun is setting over the Magic City.
And earlier, it's getting darker out there.
And earlier is getting darker. Yeah, well, we are in fall. Hi, Betty.
Hey, guys, we are, and we're getting closer to that fixed calendar end date for rainy season, which is this Saturday, October 15th. And it looks as though the weather is going to be appropriate for that. Cold front is arriving this week. And by the way, we're still dealing with another round of king tides out there tonight, some of the highest, or at least the highest this year. What we're looking at for tide times, the next high tide is going to come in at Miami Harbor just before 10 o'clock tonight, Fort Lauderdale around 10 o'clock tonight. So be ready for some of that minor saltwater flooding. If you see some standing water out there in those vulnerable spots along the coast, you know the usual ones. It has to do with the king tides. Not so much a lot of rainfall coming down because we haven't measured anything so far today out at MIA. It's been a dry one for us. And we talk about the end of the rainy season, October 15th, that fixed date. So far this month, just October alone, we have not gotten quite the amount of rain that we would normally have at this point in the month, running a 0.6 of an inch deficit for MIA. And by the way, this 2.48 inches that Miami has gotten so far this month, we got most of that yesterday. Fort Lauderdale has seen nothing. So we could use some rainfall out there, and there is more in the forecast. It looks like Thursday before we truly get into a drier setup. For now, though, we're not seeing signs of rain from Miami. Oh, no, not with all that sunshine bouncing off the waters. Temperatures in the mid-80s, but right now between Fort Lauderdale and Key West. We do see some showers on the Doppler radar way off looking south and east of Bimini. You see those. If they can hold together, maybe they drift a little closer overnight, but our rain chances are not tremendous this evening. In fact, our Skycast sees nothing for Miami. Downtown looks to be a dry night for us, so that's good for anything that you want to do outside. We just talked about the minor saltwater flooding issues, but let's take it higher up in the atmosphere and see what's going on with the water vapor imagery. We're not necessarily tapping deep tropical moisture. You can see where there are some areas of dry air, including over parts of the Florida Peninsula. So the moisture for rainfall is limited at the moment, but what will happen on Thursday, we'll get an increase in available moisture as a cold front starts to enter the north part of the state. So Thursday, we'll have a higher rain chance. We'll get some rain and storms with the front. And then Friday, look at how those shades of brown and gray start to bleed all the way down towards South Florida. That is what happens behind the front. Northerly winds take hold and we get into air that is drier, and for the low levels, air that is less humid. So tomorrow, we're still going to be a little bit on the humid side. High temperature near 90 degrees is in the forecast. Check out this 7-day planner, though, and the changes that happen. Thursday, we pump the rain chance up to 60%, but then Friday, Saturday, Sunday, it's down to 10%. So that is truly a big difference for us, the refreshing change a lot of you out there are probably waiting on again. Christy?
Yeah, look at those low 70s. Bring it on. Okay, thanks a lot. More than 65 species of palm trees in the U.S. are vulnerable to a wood-killing fungus out there, which actually could be devastating to South Florida.
Yeah, local researchers have come up with a way to find the fungus before it's too late, but they need your help.
For years now, Braham Dillon with U.S. Institute of Food and Agricultural Sciences in Davie has been on the hunt for a silent killer, a soil-borne disease attacking palm trees called Ganoderma buttrot.
Infects the lower portion of the palm, and that's where it shows up initially, and so that portion, the lower portion of the palm just above the roots, above the soil line, is called the butt of the tree.
The infection degrades the structural integrity of the palm from the inside out.
So that means in the event of wind, or even without the wind, when it's too degraded or rotten, the palms can actually fall and be a liability for pedestrians or property which is by the sidewalks or wherever the palm is planted.
Dillon says when the disease infects the tree, the lower branches will drop flat against the truck and a mushroom-like fungus will grow at the base of the tree. That fungus produces millions of spores that can spread by wind or water and through the ground to nearby palms. Dillon and his team have developed a diagnostic test to catch the disease and possibly save the tree before it's too late.
So we can receive samples from landscapers, homeowners.
All you need is a basic drill to take samples from opposite sides of the tree near the base. Allow the shavings to fall into a plastic bag and then send them in to UF's IFAS lab.
The other part of our research project here is, to develop methods to either, basically to kill the fungus, either in the soil or in the trunk.
And to learn more about how to take part in the research and stop the spread of the disease, look for that story on local10.com. Well, one Illinois homeowner's Halloween display is bringing in people from miles around. That's because Kurt Reidenbach grew a pumpkin that is the biggest in the state. Look at that. His gigantic gourd tipped the scales at 1,760 pounds. It took more than 150 gallons of water every day for 3 months to get that great pumpkin to grow this big. Kurt's second biggest pumpkin is a mere 1,520 pounds. And he also holds the title of the biggest squash in the state at 929 pounds. Everybody's got a hobby. So pumpkin is definitely this guy's.
Pumpkin growing is, he's got a green thumb for sure.
Pumpkin pie, my goodness.
Yeah. All right, we'll still head here at 6. This South Florida teacher has been arrested and charged with sexually assaulting a teenager. And we're now learning exactly how authorities found this all out in the teen's own words.
Police looking for a killer after 4 people were shot in a drive-by. One of the victims died. We're hearing from shaken witnesses.
But first, we're going to show you how the emergency supplies you collected after Ian are now making a big difference to those who lost everything. That's when Local 10 News comes right back.
Be an authority on weather with the new Local 10 Weather Authority app. Live interactive radar, live streaming forecasts, futurecast, lightning tracker, and more. Activate weather alerts and select weather from unlimited locations. Drop pins of weather-related photos or video. The power to know weather conditions anywhere. And it's completely free. Download or update the Local 10 Weather Authority app now. Search WPLG in the App Store. Like us, LOL. You're going to love us. Follow Local 10 News on Facebook. You'll get the hottest videos going viral, the top stories making headlines, up-to-the-minute weather updates, and breaking news as it's happening. So go to Facebook, click like on Local 10 News, and show your love.
You may remember last week we showed you how people in Miami Gardens were collecting so many donations for minority communities in Fort Myers trying to recover after Hurricane Ian. The supplies were collected at Carroll City Park and have now arrived in Lee County to benefit the communities with mainly African American residents who say they often get overlooked when it comes to storm relief. So necessary and so thankful, I'm sure. And that's it for the Local 10 News here at 5:30. Time now for your news at 6.
Right now at 6, safety alert.
A well-known teacher arrested and accused of the unthinkable.
This chemistry teacher is facing very disturbing charges. I'm crime specialist Bridget Matter with what every parent should know.
And it was like thunder. Crime alert. 4 people shot in a drive-by shooting. What we just learned.
Take him out, please. I can't have him in here. Take him
On
out.
the border, a judge outraged after what a teen suspect did in court.
The Parkland penalty phase jurors on the cusp of facing a responsibility like no other in U.S. history. I'm Christina Vasquez with next steps in this historic trial.
Plus, caught in the act where a suspected porch pirate thought she made a clean getaway.
Local 10 News starts right now.
Off the top at 6 today, we begin tonight with a safety alert. A South Florida teacher once honored by the White House is now under arrest.
He's accused of having sex with a teenage boy he met on Tinder. Let's get right to Local 10 crime specialist Bridget Matter live in Fort Lauderdale with our top story. Bridget.
Well, this investigation, it spanned months, and the police report that was released is extremely detailed. This high school science teacher now facing serious charges, including sex assault. This 6-page arrest report details a 16-year-old boy and 46-year-old Carlos